I said that that's not so bad. That's it.
Go to
May I please your Sir M. Hello, will be joining. He's on legs in code number 21.
How long will it take, madam?
Lordship, you will
Don't
be
have-
here in 2 minutes.
We don't have any other matter, and if this bench rises, this matter will be in limbo. This bench will not be available next week.
Lordship, them are
They have already argued. You have some points.
oh yeah, my lord.
You can make your points then. Don't repeat the points which have been argued.
Yes, my lord. May I please, my lord.
See, this is the only matter left.
Yes, sir.
And if this bench rises, next week onwards, this bench is not there. And this is the only matter. But let him
Let him
finish.
finish, Sir, my general
You are in? Which one?
supplementary cost item number 6, my lord.
50.
50.
What is your name?
Rubhan Chakma.
No, your counsel.
Deepash Dean.
Dean on the okay. Why is the number the jail appeal? Initially it was
Yeah, I think,
registered as jail appeal.
yes, sir.
Subsequently,
referred as jail.
you have entered appearance.
Yes.
Dean on the. Just keep it here. Exhibit. This is this one separately. Okay. Just keep it. Thank you. Yes, Mr. Nandi.
Yes, my lord. First, let me say that I have been attracted with section 120B, 364A, 395, 397, 201, 34. As per the judgment passed by the Honorable Trial Court. My intention, my specific point is that the section which has been attracted against me, the section 364A, the ingredients of 364A is not attracted in this case with regards to me. And as such, I just wanted to point out those points which specifically speak the truth in regards to this case in connection to me. May I please, my lord? My lord, I would like to apprise the facts of judgment passed by the Honorable Trial Court in paper book number 1, volume 5, page 1175, 1200.
Last page দেখুন তার last page এটা দিস আমি এখন তো তাহলে এখন কোন নম্বর পেজ টু কাটা What do you want to show?
Yes. My lord, may I read the paragraph, relevant paragraph?
of the judgment?
Well.
Why? What purpose?
My lord, they have apprised the fact that the confession, with regard to the confession also the voluntary statement, court has not stated anything against me that what was the role played by me to this context and how I am connected to this particular. That's what.
No, you may not. It may not be required to go to the impugned judgment.
My lord.
You can show us that there are no materials to connect you.
Yes, that's what, my lord. Prior to this, let me the relevant, that is in summarized way. So let me read the summarized part and then I'll point out those points.
Yes, so which volume? We're not getting the
Part 1, volume 5.
part 1, volume 5. To page volume. Page 2 to area volume. Volume? Oh, volume 1. Volume 1. Volume 2, volume 3. 4, 4. 5 volume. And the examination of interviews, yes. Have you got? Yes, part 1, volume 5. I don't know. This is part 1, volume 5, no?
Yes, yes.
And that I have. It is here. Something is missing. Logic. You go to part 2. Part 2. Part 1, volume 1, 2, 3, 4. I don't know. 242, 242 hobo nore. Part 1 kini to one business and medieval.
I think the first page is missing.
No, first, but the index will be there.
Because this lots of
Part 1.
oh, I'm sorry. This is
Please 118.
I don't know.
114. Yes, I think
It should start from 1148.
correct.
I think that's it. Let me see it. 1148 hobo. You can read it slowly. We can read it. Yes.
Learned senior civil public prosecutor Sri A.K. Singh has submitted that the prosecution case mainly basis
Which
itself on
page?
page number 1183.
11? Part of the judgment.
Yes. Point number 6. Right.
Yes.
Learned senior public prosecutor Sri A.K. Singh has submitted that the prosecution case mainly based itself on confession statements of the accused and on the case identification parity. It has submitted that the confessional statement can be made based on the conviction if found truthful. He has also stated that the confessional statement stands corroborated by the prosecution witness number 1, 4, and 5.
Oh. Okay. You can go to creator hobo. 103. Yes, please.
Learned senior public prosecutor Sri A.K. Singh has submitted that the prosecution case mainly based itself on the confession statement of the accused person and on the test identification paragraph. He has submitted that the confessional statement can be made basis of conviction if found truthful. He has also stated that the confessional statement stands corroborated by the prosecution witness number 1, 4, and 5. He has submitted that the prosecution witness number 1, 4, and 5 are not only eyewitness but also victim of the offences against him by the accused person. He has submitted that the prosecution witness number 5 identified the accused number 2, 3, and 4 clearly. My lord, I am accused number 4 here. Yes. He has also stated that the eyewitnesses victims also identified some of the accused persons as persons involved in the abduction of Tutul Chandradev and have corroborated one another in all material particulars. He has argued the fact that the accused number 1 and 2, my point, my lord, he has argued that the fact accused number 1 and 2 made statements leading to discovery of the skeletal remains of the Sri Putul Chandradev and Sadan Nath and also lead to the discovery of the personal belongings of the two deceased, which were identified by the family members, and with sufficiency he has laid credence to the story of the prosecution. My lord, in this particular para, my lord, I would like to point out that I am accused number 4, my lord, and I have not led to any discovery where the discovery of the skeletal remains or of the deceased persons were there. It resembles, my lord, that I have no knowledge regarding that particular incident and the fact which happened on that particular day. And my lord, reading into this, my lord, he has stated the way of DNA fingerprints with regard to the skeletal remains of Putul Chandradev and taking the same together with the report of the autopsy and matching of its dental records kept in the hospital in England and confirmation that the pacemaker recovered with the skeletal remains were implanted in the body of the Putul Chandradev. Proved beyond reasonable doubt and the skeletal remains were Sri Putul Chandradev and the fact that the abduction of the said victim by the accused persons were proved and the skeletal remains were discovered were being shown by accused number 1, proved beyond reasonable doubt, accused number 1 and 2. And the accused persons were involved in killing of Putul Chandradev. He has further stated that even though DNA profiling could not confirm, my lord, this particular point is again the different version, my lord. Even though DNA profiling could not confirm the skeletal remains of another person to be that of victim Sadan Nath, the fact he is not abducted and was proved beyond reasonable doubt, and that along with the skeletal remains of the personal belongings and the clothes of victim Sadan Nath were found, and that after his abduction Sadan Nath has never been seen, proved beyond reasonable doubt, and the second deceased victims also killed by the accused persons after being abducted. My lord, here this particular para specifically speaks regarding that there was a matching. However, the report shows before this honorable court that that particular point is not matching, my lord, and it has not been proved. Now coming to the other side, my lord, this is the part of the defense argument, my lord. On paragraph number 7, my lord, on the next page. May I read, my lord?
Yes.
On the other hand, learned counsel of the defense, Sri A. Chaudhary, assisted by Advocate Ann Devi, has submitted that the prosecution has not been able to prove its case and the charges leveled against the accused persons beyond reasonable doubt. He has submitted that the prosecution's case is full of blemishes and the alleged genesis of the incident leading to the case is not believable. He has argued that the prosecution case was that there was a quarrel between accused number 9, Jamaluddin Majumdar, Budul Mia, and Sri Putul Chandradev with regards entitlement of the latter to royalty of the bamboo, and that was been carried on behalf of the former, which according to the prosecution case itself was resolved, and therefore such a petty quarrel could not have a spiraled itself into huge conspiracy of the abducted Putul Chandradev ultimately to kill. He has pointed out that the prosecution's evidence shows that, well, when Sri Putul Chandradev was proceeding towards Bhairavi on the faithful day, he has met accused number 9. And these, according to the learned counsel of the accused, showed that there was no ill will between two, and therefore the theory of conspiracy have been hatched by accused number 9 and accused number 7 for kidnapping of Putul Chandradev fails to inspire confidence. It has also submitted the confessional statement of accused number 1 to 8 are not worthy of reliance and were tainted in view of detraction by all of the said accused at the time of recording of the statement under 313 of the CPC 1973, CRPC 1973. He has stated that it was clear from the material on record the confessional statement was extracted for the duress and the accused persons were so brutally influenced by the investigation agency that they could not overcome the fierce accusations even after several.
Why are you reading the submissions?
Yes, my lord.
Let
Why
us
I'm
to
reading
the-
the submission, my lord, is
Take
that
us to the findings.
yes, my lord. I'm just pointing out these particular points, and I'll come to that point, my lord. These are some of those points specifically say, my lord, this particular influenced by the investigation agency, my lord, I was earlier taken before the judicial magistrate, and later on that particular day, I have been asked questions, I have not replied. On the similar context, I have been again called for and asked for giving my evidence and my confession, my confession, my. And on that point, some questions were raised to me, which was not similar to the other persons which was raised to them. May I point out those points, my lord? Right now, or my lord, on the next part?
Right now, make your point. Right now.
Right now.
You had given a confession. You had
Yes,
made a
ma'am.
confession.
Yes, ma'am.
So why that confession should not be taken into consideration? Tell
My
us.
lord. The confessional statement is part 2, volume 1, my lord.
Yes. Which page?
My lord, page number 213.
213. Yes, please.
My lord, it may be kindly checked with page number 178. 178 with page number 230.
Yes.
My lord, one specific question was asked in page number 178 that has anybody tutored, threatened, or allowed you to confess? This question was omitted in my part, my lord. I have not been given any opportunity to reply on this particular question. That has anybody tutored, threatened, or allowed you to confess, my lord?
See the records. Yes, sir. Make a note, madam. See the original records. In this, he's trying to make out a point. Yes, Mr. Hollow. Mr. Hollow is trying to make a point that so far as his client is concerned, had made a confession, and he's trying to compare the confessional statement of his client vis-a-vis another appellant at page 178 of the paper part 2, volume 1. 178, there is a question. Has anybody tutored, threatened, has allowed you to confess? That question is not there. These are format questions. Maybe while typing, it may be omitted. Just check the records. Record আছে না? See the confessional statement of Rudhan Chakma, A4. Yes.
Similarly, my lord, the deposition given by the JMFC, my lord, on the particular PW11, there was one relevant part. I'm just reading it over, my lord. Before recording confessional statement, I asked the accused person whether they got treatment from the police. I also asked the accused whether they want to make confession. The accused was given sufficient time for reflecting consequences of the confesses, so I find the confession made by the accused voluntarily. My lord, Honorable JMFC didn't say or specifically said that there was the reply given by the accused with regards to any threatening or not. It is also omitted in that particular point. At the point of chief also.
We'll see the original record. These are yes, you can proceed.
My lord, I'm coming to the judgment part. Page, page number 12 of the 9th, 12 of 9th of the judgment. Paragraph number 7, my lord, the next page. He also argued that the statement leading to the recovery attributed to the accused persons were obtained under duress. In fact, there was no recovery on the basis of the statement made by the accused, and all the recoveries by state magistrate are not reliable. He also pointed out the contradiction in the statements of the witnesses of the recovery of the skeletal remains of the two victims in case there was a different time of reaching at the place of recovery. Make the evidence as recovery tented not but there was two different times, my lord, of the skeletal remains which were selected. Moreover, my lord, if the inquest report will be checked into, my lord, apart from his family member, and it is admitted by him that Sudeep Dev, that nephew of that particular deceased person, apart from him, there was no independent witness who have accompanied along with them in the place of such inquest. And it is duly admitted by Sudeep Dev in his statement, deposition. Will I read that?
No, no.
It was further argued that the testimony of the prosecution witness number 32 clearly showed that the DNA profiling was not 10% pure test, and also stated that it was not possible to obtain an uncontaminated DNA sample from the skeletal remains which were recovered after considerable lapse of time and were exposed to weather and dust. My lord, this particular point itself reflects that the DNA was
These have been argued.
Yes,
Mr.
my lord.
Counsel, don't repeat these arguments.
My lord.
Not matching up. If you have some independent argument, please
Yes.
make. Please make. Otherwise, no point repeating. See, there is a confession statement against you.
Hello.
You have just tried to point out that in the format, one question is not there regarding tutor. We have noted that. We'll see from the original record. But that submission of yours perhaps may not be correct. Why we are saying? Because that's a format. And these are in the paper book you are having the type copy. It's a type copy, not the photocopy. So probably in the records, your contention may not be correct, because those are normally will not be missed. It cannot be missed. It's a format. The part in the confession, if you want to say, make some submission on the actual confession made by your client, you are free to make. One confession, one argument has been made by one of the counsel that it is not inculpatory, it is exculpatory. He tries to wriggle out of the situation. So those are not to be taken into consideration. You have not made that. What is your confession? Please read your confession. Come to page 214.
I came to Bhaichara with Kalije from Lachera to cut bamboos. Then Kalije took me to the house of Phagan to stay there. In that night, I used to keep sitting in Phagan's house. Kalije, Sahadev, Purapa, Krishna Madhav, Kalpanu, Master Sahadev, Bhagendra, and Nandu sitting together, discuss certain matters. They were sitting little far away from me. After the discussion was over, I asked Kalija and came to learn that they had a plan to kidnap a person. After a while, they went to the place of kidnap. Kalija asked me to remain with him, and I did so. Later on, Kalija, Nandu, and Master Sahadev and I kept sleeping in the place of kidnap. On the day of Kalpanu, Sahadev, Hurappa, Krishna Madhav went to Bhaichara. They again came back for the following morning, asked Sahadev Master and keep me to uh, and me to keep hiding beside the road. Sahadev, Hurappa, Kalija, Krishna Madhav, Nandu, and Kalpanu proceeded to little farther and keep hiding beside road. At about 10 to 10:30 a.m. on Wednesday, first we heard sound of an approaching vehicle, and while saying vehicle is coming, Hurappa came out of the jungle, whereupon together stopped the vehicle immediately. We saw 5 persons inside the vehicle. I did not know. I also did not know who was to be kidnapped. Thereafter, we got into the vehicle and led it along the road in the jungle. After crossing some distance, the vehicle got some technical snag. Then we started proceeding on foot. We found a truck and a person standing on the road. Kalija and Master Sahadev told the name of the person who was standing there was Sadhan Nath, and he knew us. And they and that, if he was left, he would create trouble for us. Thereafter, we took him along. Thereafter, I stayed in the jungle of Bhaichara. That sitting at the place inside the jungle, Purabhas Sahadev told Prutuldev was one of the 6 kidnapped persons, and he also told Prutuldev that they would be released on payment of ransom of rupees 50 lakh. Then Prutuldev told that he would try to pay an amount of rupees 30 to 40 lakhs. Then Hurappa, Sahadev, and Krishna Madhav snatched the gold chain, 7 to 8 gold rings and currency note from Prutuldev. The Hurappa said that Krishna Madhav went to the house of Khagan and also while brought rice, water, and blanket therefrom. After taking the meal, we came near the railway track and instructing the manager of Prutuldev to bring the demanded amount to Terenga Khan within 3 days. We released 4 persons. Then I proceeded along with the railway track and entered deep into the forest. A person, Patipura, by name, came and led us along the road. Thus, we, along with the 2 hostages, stayed in the jungle for 2 days. Keeping us there, Patipura left the place. After 2 days, a person called Hurappa, Sahadev, Krishna Madhav, and Kalija away by means of signal through whistling sound and held talk. We did not know what they talked. They came back from after some time, and Kalija said that the Patipura came and informed the army Riang were coming to the plains to catch us. So he asked us to kill the 2 hostages. And I told that there was no necessity to kill them and it should be released. They should be released. We should release them and leave the place. The Kalija, Krishna Madhav, and Hurappa told me that we would fall into the trouble if they would not kill. If they were not killed. Thereafter, Master Sahadev cut bamboo of Muli variety and made rope thereof. We took Sadhan Nath and Protuldev to near a nala and covered their eyes with handkerchief. There are 4 persons: Krishna Madhav, Sahadev, Master Sahadev, and Rupthan. Put nose on the neck to Prutul Dev and Sadhan Nath and started pulling the nose from both ends. Kalija, Nandu, and I kept seeing.
Oh, what is your name, Rupdhan?
My name is Rupthan, my lord.
Then why this thing? Thereafter 4 persons.
Yeah, this name is also reflected. Rupthan is against it.
Whose statement is this?
It seems to be my statement, my lord, given before the JMFC.
Thereafter, you please.
Yes. After pulling the rope for some time, Sri Sadhan Nath died and Prutul Dev fell on the ground in moribund state and the rope got torn. Then Sahadev told that he was still alive and he should be beaten with lathi. We together beat up him with lathi. I was unwilling to beat him up. Sahadev told that if you did not beat him, I would not give you. I would not be given money. I dealt 2-3 blows, then Putuldev died. Then we kept the 2 dead bodies in drain and covered them with leaves, and Sahadev put a large stone over the dead body. Thereafter, I entered the jungle on the following day. Everyone left on the respective houses. 2-3 days thereafter, Kalijay came to my house and then taking me along went to the house of Krishna Madhav, saying that he had to go to Silchar. Kalijay asked Krishna Madhav for the gold rings. The Krishna Madhav gave Kalijay the gold rings. 2 gold rings out of the gold rings received from Krishna Madhav were given to me. Then I was crossing a river, a ring fell into the water, and I sold other to rupees 1,000. I sold the ring to Rajkumari.
This is inculpatory.
Yes, my lord, but the statement is not given voluntarily, and this is not my statement, man. This statement has not been read over to me. And I was not being given the opportunity because I was behind the bar since a long time. And
What opportunity?
to defend myself before the court, my lord, to express my views that this statement which have been taken, I have no knowledge that what was the statement written behind. That whether the statement is connected to me or not, whether it is creating.
You are not given the opportunity means in the argument, nobody represented you.
My lord, at that point of time, I was unable to appear pro any counsel, my lord. I was behind the bar.
At the time of confession, there is no requirement that you have to have a counsel.
And moreover, I have retracted the statement on 313, my lord, and it is specifically stated.
Where?
Part 1, volume 4.
Part 1, volume 4. Yes, we have page.
384.
Hmm?
Page number 907.
907. Yes, please.
My lord, question number 384. Will I read the answer?
Yes.
PW11 stated that on 16/9/2005, you and Patipura Chakma were brought to him for recording their confessional statement under Section 164 CRPC. He told them they were not bound to make any confession and gave time to them to reconsider the decision. My answer was that I was taken to the court for the last 4 or 5 days prior to the CBI had given me a statement in writing. And I was told by them to memorize that and to give the statement before the magistrate, or else they would kill me in encounter. On the first day I was taken to the magistrate, I told that I did not want to give statement. I was not involved in the case, and thereafter I was sent back to jail. Then the CBI people had tortured me severely, and then on 16/9/2005, I was again taken to the magistrate and was told that he did not give the statement according to what they had dictated. They would take back me the CBI. They would take back me to the CBI custody and kill in fake encounter. Thereafter, I gave the statement according to the wishes due to fear. This was my statement, my lord. And the next para is also connected.
Due to fear.
Regarding the free and voluntarily confession, my lord, I have denied. It is false. This is not, I have not made any such statement. Will I read that part? 385.
385, yes.
PW11 has also raised on 19/9/2005 at 11:30 a.m. Rudhan Chakma and Batipura Chakma were produced before him, and both of them gave their free and voluntarily confessional statement before him, confessing that you, along with them and other accused, Sahadev Chakma, Master Khagendra Chakma, and other entered into conspiracy to abduct the deceased Putul Chandra Dev for ransom and abducted the deceased Putul Chandra Dev, and after receiving ransom of rupees 5 lakh, killed him. and as well as the this is sadhana. This is false, and I have not made any such statement. Next question. PW11 also stated before recording of confessional statement, he asked accused Rudhan Chakma and Batipura Chakma whether they had tortured by the police, to which they said that they were not. I was not asked any such questions.
Okay.
Questions were not asked to me. My lord, in question number 390, my lord.
390.
Yes, ma'am. PW12 and 13 has deposed that on 4/9/2005, all the above mentioned persons first went on motor vehicle to Ramnathpur and then proceeded on foot. And Sahadev Purapa and Krishna Madhav Chakma took them to Bhaichara forest, whereafter they crossed a stream and reached the place where they found heaps of human bones, skulls, one pacemaker, one shirt, one pant, shoes, socks, purse, etc. I have no knowledge as I was not arrested till then. He has no knowledge regarding the fact that where was the skeletal remains, and it was already reflected in the judgment also, my lord. These statements were not given by me. The statements were given by somebody else on discovery of that particular point. And question number 394, my lord. PW13 also stated that two accused have stated that after killing Pratul Dev, they have concealed two rifles, uniform of Bhaichara, and they also and that they could show the place if they were taken. I am not aware of, my lord, this particular point. I have already denied this particular fact, sir. And whatever the point which I have said, my lord, question number 386 is specifically written. I was not asked such questions, my lord, whether with regard to the making of the confessional statement there was any torture made by the police or not. These are the relevant questions, my lord, with regard to Stephen. My lord, may I come to the point of judgment?
Judgment, why? Why are you going to the judgment? Tell us your points.
My lord, 2-3 paragraphs I want to read, my lord.
Now, what is the purpose?
With regards to confession, my lord, findings of the court.
Now, you have shown us the material judgment finding where it's part of challenge. You have shown firstly that while you got a chance in 313, you have retracted. You have also shown that part of the confession wherein the question as to whether you are being tutored was not put to you. You have also shown us the reply to 313 that you had made the confession out of fear.
My lord, may I be allowed once to read this particular paragraph?
Which why? Why you read a judgment in a criminal appeal? We are appreciating all the evidence. Judgment will hardly have any value now. Entire thing is, do you read a judgment in a criminal appeal?
Okay, my lord.
Now, what point do you want to drive home? Is there any specific point?
One specific point. My lord, in one two one seven, my lord.
Yes.
Para number 34.
Yes.
The Honorable Supreme Court in India has, in the case of Shankaria versus State of Rajasthan, as reported in AIR 1978 SC 124, 1248 as follows. It is a well settled that a confession, if voluntarily and truthfully made, is an efficacious proof of guilt. Thereafter, when in a capital case, the prosecution demands the conviction of the accused primarily on the basis of the confession recorded on 164, the court must apply a double test whether the confession was perfectly voluntary. my point is that my confession was not perfectly voluntarily, my lord. And so, if so, whether it was true and trustworthy, my lord, regarding that particular place where if I was there particularly at the time of killing of that particular person, I could have pointed out that place at the time of discovery, my lord. I have not pointed out the place, and it is not given by me also. So it is not true, and neither it is trustworthy, my lord. My submission before this point.
No, you said that you are not even arrested by the time. So
Yes, my lord.
the question of you making a disclosure statement will not arise.
My lord.
That you have said.
Yes, my lord.
And
And
it has got nothing to do with your confession.
and my
The
lord,
voluntariness and truthfulness to examine these two aspects, your disclosure statement will not have any impact because you're not been arrested.
Yes.
Disclosure statement has not been made by you.
Yes.
You can independently challenge or drive home your point.
my lord, there is one disclosure statement. There is one disclosure statement with regard to the ring method. May I read that?
Not of the skeletal remains.
No, no. Only with regard to the ring. May I read that point?
Yes.
My lord, part 2, volume 1, page number 50.
Yes.
I am as stated above, having been examined and inquired, I state that I lead you and your team along your supporting staff to Lalchera market, where I can point out the shop of Sri Rajkumari Chakma, wife of Durga Mohan Chakma, to whom I had sold one golden ring of Putul Chandra Dev to Srimati Rajkumari Chakma against the payment of rupees 1000 as my own shares. This is the disclosure statement made by me. Now, my lord, the independent witnesses are Ajal Datta and Lakshman Malakar. My lord, I would try to read that particular point of Lakshman Malakar, who was the independent witness. Read up to
Who is Lakshman Malakar?
independent witness who have
Regarding?
been there regarding the seizure of that particular gold from the part 1, volume 1. Page number 99.
Statement of whom?
Lakshman Malakar. I'll just read the relevant relevant line.
Yes.
That is at page number 103, my lord. From above one. 6 number line. I did not accompany the investigation team for recovery of all the.
Did not accompany the investigation team for?
Recovery of all the rings. Only this point, but the rest all a bit read over.
Okay.
Next 2 months.
Next one, what is it?
I was present at the time of recovery of 3 rings. Two of the rings were recovered from the house of Sapam Burga.
Please read the next two lines
Hello.
of 103.
I was present at the time of recovery of the rings. My lord, two rings were recovered from the house of Sapanpura and one from Rajkumari Chak. My lord, these are contradictory. One they are saying that he was not accompanied with the investigation team. Again, he is saying that there was a recovery of two rings. My lord, which one to be relied upon? My lord?
But you should be fair enough to read the two lines also. You read just one line.
No, my lord.
By making a submission that is contradictory, that is a different submission. But first you gave an impression that he made a statement he was not even accompanying the investigation team. But he says thereafter he was there.
My lord,
there
I'm
are
sorry.
3 rings.
My lord.
Not one ring.
And in connection to the rings, my lord, the statement of Ruphan, Rajkumari also, my lord. That is in PW21, my lord, page number 160.
Hmm.
4 years back, once Sri Ruphan Chakma sold me one gold ring with white stone. After 10 to 15 days, CBI personnel came to my house to seize the said ring. Police personnel were also with them. I put my thumb impression on the paper prepared by CBI. The paper was read over to me in Bengali. Material exhibit number 1 is the golden ring with red stone. Earlier, I said it was white, but the fact it is red stone. Accused Ruptan Zakma in red t-shirt is present in the dock, and I know him. Now the stone, the golden ring, whether it was white or whether it was red, and who identified the white and who identified the red is totally different. There were two red stone, my lord. Material exhibit number 2 and material exhibit number 4, my lord. And material exhibit number 4 was identified by Sudip Dev, that is PW number 3, my lord. My lord, I would like
the rings have been connected to the deceased. Rings have been connected to the deceased.
As per the statement of Sudip Dev, he could identify the ring that to be connected with the deceased. And apart from it,
Sudip is a related relative.
nephew of the deceased. My lord, in the judgment, my lord, the relevant para number 40, may I read, my lord? Regarding the confessional statement of accused.
Yes, please read.
Yes. From the confessional statement of accused number 1, it is clear that the accused number 6 has agreed to lead the accused persons of the kidnapper to proper hideout inside the jungle, where when he has raised the question as to where the kidnapped persons would be kept. The confessional statement of accused number 7 shows that that after kidnapped, the accused number 6 had led the kidnapper to the hideout. This also gets confirmed from his own confessional statement. It has also seen that the same has been corroborated by the confessional statement accused number 8, who has stated that the accused number 6 has taken him to the accused number 7. And while on their way, the accused number 6 has stated to the accused number 8 that the Khangendra Chakma has sent him to accused number 7 for the purpose of kidnapping Putul Dev. Here, all the relevant accused numbers are different. I am accused number 4, my lord. Again, I'll read the next 2 paras also. These are related with the confession again. From what has been discussed above, it is clear that the conspiracy was to kidnap Protul Dev from a ransom, and only in order to effect the conspiracy, the prosecution witness number 1, 4, and 5, prosecution witness number 1, 4, and 5, as well as Sadhan Nath and Chungul Ali were abducted. It is clear that two motorcycle born young men, namely Muhammad Ataur Rahman Laskar, Muhammad Chungul Ali, were abducted so that they were not in the position to frustrate the purpose of the accused person by informing the police or otherwise. Confessional statement of the accused persons, and more particularly that of the accused number 2, shows that the Sadhan Nath was also abducted in order to evade the process of law and to give effect to the main conspiracy. The intention to abduct all these persons had developed at the place of occurrence. Kidnapping was nurtured by all the kidnappers, and answer to fourth point of determination is also answered in the affirmative. And the last para, which is related to the confession, is that, as mentioned above, the accused number 1 has stated in his confessional statement that he and his accomplice has taken away 8 rings and 1 necklace from Putul Dev, and whatever was in the hand of the manager of Putul Dev. The accused number 2 has also confessed to the fact that after Putul Dev and other victims were kidnapped, on being asked, the accused number 1, he had checked the valuables were with the hostage and had thereafter found money in the bag of Putul Chandra Dev, and he had been taken rupees 1500 from the prosecution witness number 5, and as well as pillion rider Chungul Ali. It is clear that they were armed with look like weapon oblique firearm. It was but natural that the victim were in the fear of instant heart or death, or thereafter they handed over and allowed the valuables to be taken by 2 accused. Presence of all the other abductors of the kidnappers also acted as an additional source of threat to the victims. The prosecution witness number 1 has stated that the miscreants have taken away cash amounting to rupees 20,300 from Putul Dev, and the part of testimony has already been mentioned and was questioned during examination. Prosecution witness number 4 and 5 was also stated that the prosecution accused person took away the valuables of Putul Chandra Dev, and prosecution witness number 5, and that for the state purpose they physically assaulted with victim Putul Chandra Dev. Now it is clear that the victim were put in fear and hurt, and the fact was inflicted by Putul Chandra Dev, and they were in the wrongful confinement, and valuables were taken from the possession of accused person, and the accused person involving were accused number 1, 2, 3, 4, 5, 6, and 8. Now my name is reflected. But in the confession part, what did I confess with regards to this particular incident, my lord? It is omitted. It is not reflected.
It will not make any difference. You see, the confession is before us. The aspect of truthfulness as voluntariness will examine whether that was discussed in the judgment while convicting you or not. How does it make a difference? If you say that there was no confession, instead of that, in the judgment, it has been wrongly written that you had confessed, then matter would be different. Now, confession is before us, we'll examine that part. Anything else?
My lord, I want to place
Citation, please.
AIR Online 2024 SC 12.
Online. Let's see, page 12.
Yes. My lord, I have been punished under section 364A for life imprisonment.
Yes.
My lord, the relevant para is at page number 9, my lord, paragraph number 14. The court in case of Sheikh Ahmed versus State of Telangana has held that in order to make out an offense under section 364, 3 conditions must be met. There should be kidnapping or abduction of a person, or a person is to be kept in detention after such kidnapping or abduction. And there is a threat to cause hurt or harm to a person, and the accused have been by their conduct give rise to reasonable apprehension that such persons may put to death or hurt. or the cause death and hurt to such a person in order to compel the government of foreign state or intergovernmental organization or any other person to do or abstain from doing any act or to pay a ransom. The necessary ingredient which the prosecution must prove beyond a reasonable doubt before the court, and not only at the act of kidnapping or abduction, but thereafter the demand of ransom coupled with threat to life of person who have been kidnapped or abducted must be there. My lord, in my case, my lord, there is prosecution could not establish the fact that I have demanded any ransom or there was any role played by me in demand of any ransom.
What about 34?
Common intention. My lord,
Is it required that every of the member has to play some overt act?
my lord, there
There
were
conspiracy is also there, 34 is there. Your role it would be a different role, but if there's a common intention, you are roped into it.
my lord, apart from the victim, my lord, there are other several independent witnesses who have not been brought for examination before this trial court matter. So there is a doubt raised with regard
Apart
to
from the victim means victim has passed away. Which one?
my lord, the victims like the PW number 1, 2, and 4, my lord, who were in
Victim?
they were one of the victim, my lord, this case, 1, 4, and 5.
What kind of victim?
They were in the jeep. They were accompanying with Putul Chandradev.
What have they said? 1, 4, and 5?
My lord, they said that they have identified me at the point of abduction. They have identified. This is the relevant point. If, my lord, I may read it over.
That's okay. Now, what are you trying to show in this Neeraj Sharma?
My lord, in Neeraj Sharma, my lord, I would like to say that 364A is not attracted against him. There are no ingredients in connection to the 364A under which I have been punished.
Okay.
My lord, will I read the PW1?
No, this is okay. 1, 4, and 5 have noted.
Yes. My lord, humble prayer is that the person initially who have conducted the investigation, those witnesses are not been called upon. At the time of ransom also the police were there. They have identified the vehicle, but they have not identified the numbers of the vehicle number of the vehicle. That is also one of the doubtful point, my lord. At that point of time, many persons were there, but they couldn't say the vehicle number, my lord, on which they came or they went. Upananda Riyang was not sent for trial despite having the confessional statement, my lord. Pacemaker do not contain the name of the number, model number. Independent witnesses, my lord, Virendra Singh, Kailash, Sipra Dev, and Shishav Dev were not examined, my lord. That is reflected in part number 2, volume number 2, page 393, 394. My lord. Tungul Ali, whose name is reflected in each and every statement, my lord, he was not made witness in this particular case, my lord. No police member identified any accused while handing over the money and
defending an order of conviction.
Hello.
Now the prosecution thinks that with this number of witnesses, our job is done.
Hello.
Can you say that no, prosecution, the trial is vitiated because other witnesses have not been called?
My lord,
It's upon the prosecution to Lesser the number of witnesses, better for them. It's the quality which matters.
My lord, I have no problem with that. But main issue is that there has to be an independent witness. If there were independent witness, those statements are also vital, my lord, with regard to determining the case. If there were totally independent witness, because those victims,
But
one may
are
be
there
biased.
lack of evidence in this case.
Yes, lack
So
of.
far as the evidence given by these witnesses are concerned, is it not sufficient?
My lord, the victims are connected to the deceased person, and the conspiracy hash is totally different. As per the judgment, it is also reflected that the conspiracy hash was totally different, and it came out to be a different point. Now, my specific point is that those victims who are stating may be an interested or partisan witness.
Okay.
These are my submissions, my with. I don't maybe take it from. What what the legislative
Yes, that first, yes. It's not in the format. So these are certain questions under the heading 6, which says in order to ascertain whether the accused is prepared to make a statement of his own free will, he is next examined as follows. So certain questions are put by the magistrate. This is a relevant question, but if you read the other questions and the answers, I think 6, not asking that question may not be fatal. May not be fatal. But that question, he may be correct in contending that question was not put to him. It's not a typographical error in transcription. It is not there. Okay.
doctors are the better case where the accused dictates with direct evidence as well as circumstantial. Direct evidence with regard to the offense of
kidnapping, extortion, or these are the witnesses before that the accused person they abducted and they tortured and finally got extorted. With regard to witness number 1, 3, 4, and 5, they are the eyewitnesses. Therefore, it can be said that there is a direct offense of abduction. With regard to lot of the other evidence, the prosecution has examined PW1 Jalaluddin Mujahid, who is the brother of the victim, 3 is the nephew of the victim, 4 is the driver, Santosh Sohar, 5 is Sultan eyewitness, but the stand taken by fans that one independent has not been examined. Because the abduction, when he was present at the time of abduction, that this has been examined. But Abdul Rahman Lakhar is certified. Is one of the persons was there all along when all of them were abducted. One of the motorcycle boy Abdul Rahman Lakhar is certified.
Yes.
So the stand is not considered other stand that no independent stand. And with regard to lordship, leading to discovery lordship, their stand is that there is no independent. And secondly, lordship, the witnesses has not stated with regard to the fact that it is the accused person who has led them to discover the material. So lordship see the evidence of PW12, PW13, PW16, and PW24, PW28. These are the witnesses who stated that this accused person has led them to discover the articles which were found and which were seized by the
So it is under 1,
PW
12,
12.
13, 16, 24, and 28.
Yes, 12, 13,
16,
16,
24, and 28.
24, and 28. These are the witnesses. The prosecutor goes through the evidence. Dear Lord, with regard to the stand that the procedure has not been adopted, the evidence, the IO has not reported, simply they exhibited the disclosure statement. That is also wrong. The lordship sees the evidence of PW12 and PW15, PW12, PW13, PW16, Subrato Day, regarding the recovery of the skeleton and other materials, Exhibit 7, seized by police here. The lordship sees the evidence of PW16 clear that on this is stated that on the date by the accused person, they found all. Now, lordship, I'll go one by one. With regard to Jamaluddin.
Yes.
He is the prosecution story is that this
Number is PW1.
no, accused number 1.
Okay.
Accused number 9. From the start, accused number 1. He is the perpetrator of the entire crime. He is the person who had the consent with Hogan Group and lordship made the other accused person to abduct the victim and to extort money. Find the death of the. So the role of this Jamaluddin can be transferred from the evidence of lordship. They turn hostile, but the law regards to hostile speak there. To the extent that it supports the case of the. So may I read the evidence of Peter 14 first? So this is turn hostile lordship. But TW 15 is 145.6, it's for 145. TW 15 was TW 40 plus 142, page for 140.
Page
Page
1.
142 of volume 1. Part 1, volume 1. Part 1, volume 1 consists only the evidence of cases along with the chart. Page 140.
That's all. PW 14.
TW 14.
Yes.
Lordship, may I read? I am working as clerk of Sophie here at Bhairav. I also work with PC Dev at Toranga for 2 months. I used to keep account of bamboo which were brought from Mizoram and stock the bamboo as per the instruction. When we stopped the bamboo, Budulmia is Lordship, the accused number 9, Jamaluddin. Witness identified the dog. This contractor informed his name of the contractor as Akbar Hussain. Budul Mia Jamaluddin Majumdar on Wednesday discussed the matter with PC Dev. On Wednesday, usually PC Dev comes to Choranga. When we stopped the bamboo of Budul Mia, the actual man who cut the bamboos and hold the bamboos are minor and not in focus. Then we release the bamboo. Except this, I do not know any other CBI official recorded my. As present, I do not remember what I wrote. At this stage, he was declared. So this part of it, regarding the fact that there was a business transaction for Budulmia and the victim, they used to get your of bamboo. And on one fine day, on the instruction of CDF Lordship, these witnesses stopped. When we stopped the bamboo, Lord, the clear indication that they stopped the bamboo of Budulmia. This contractor informed him of the contract was Akbar. Budulmia, Jamaluddin on Wednesday. The day is also fixed on Wednesday. Discuss the matter with state on Wednesday, usually comes. So the fact regarding the visit of the witness has been corroborated by the other evidence also. And the fact regarding the business carried out by CDF and Jamaluddin is also corroborated by this profile. So from this is clear that PCDF and PCDF, Jamaluddin, they had a relationship with regard to the business of them. And PCDF on the sorry, this witness on the PCDF had stopped the web. Now, Lordship may kindly come to page 145, TW 15. This case was also done by Lordship. This was done by, but the part has been supported by
Page
145.
145.
Yes.
PW 15.
15, Lord.
Akbar Hussain.
Akbar. Yes. I work under the contractor of bamboo. I work under Dulmia, Jamaluddin Majumdar. At present, I'm working in the Bulbul enterprise of Bulbul. All the bamboos are released after the payment of royalty at Bhairavi Toranga. On the instruction of PCDF, his Munib stopped the bamboo to take royalty. So that is clear that on the instruction of PCDF, the bamboo was stopped. If bamboos are from the local area, the Mahaldar purchased the bamboo. If the bamboos are from Mizoram, the royalty paid. accused Budulnia Jamalik present today. My brother Sharif Ali was working with me under so PW14. Now this is very important. When members of Budulmia was solved, I informed. So clearly PW14 says the bamboo was solved. Bamboo of Jamaluddin was solved. Here was can be inferred from the evidence of that there are certain things on which there was a dispute between Sisidev and Jamaluddin with regard to bamboo. So now, may I read the evidence of now PW Lordship then with regard to Jamaluddin? PW 29. PW 29.
Page.
Plot. Page is 189.
Yes. Sukir.
Not-
Sukir Ali Laskar.
Yes. Sukur Ali Doctor. I have appeared in the court as I have received summons from the court. I do not remember CPI Emeka's recorded my statement. I have studied up to class 1. Lordship, kindly come to line number 5.
My statement.
My statement was recorded by at Bhairavi Majora. I know Khagendu These witnesses clearly that identity that Khagendu was a timber merchant and who used to purchase timber from local contractors and sell it to one. Could I have seen K. Sakma in the court? He also identified her. And I have identified him in the court today. He is my neighbor. He has visited town with me. I used to visit his residence and I also worked for him for some time. He used to pay me daily wages in the weekly basis. After 2-3 weeks, I had quarreled with him due to non-payment of my wages. And later on, called my local chief of that Rajai Jali, namely, so there are meetings on the Panchayat regard. Thereafter, I stopped working with Hogan. I know not that in this case, I know accused Jamaluddin. He is present in the court today. He had a business in the bamboo as well as cloth shop. Udul and Hogan knew each other. And they were in the same line of business. I never worked with Putulmia Jamaluddin. My younger sister, I used to visit shop of Putulmia for purchasing cloth. Before my quarrel with Putulmia, I used to work with Cotton Shop for the date of may now come to date of 195. Thereafter, about 10 pieces of blanket. When we were in the shop of Putulmia, then we told Khogendo Sakma to buy it for
195.
191. Next, it starts from page number 190 down below, but the line starts when we were.
Yes. When we were.
First, let us read 4 lines above that one. 5 lines. Since he is also engaged in the business of timber, after some time, Khogendo Sakma came to Gurmara Bazar and took myself at Gorang Kansar to the shop of Budulmia. Around that time, Jamaluddin Budulmia also present in that shop. Khogendo Sakma also sit inside the shop opposite Budulmia. I and Kansa started to purchase the shop. Gorang Kansa not know Assamese. An employee Budulmia named Soto was given the cloth. When we were in the shop of Budulmia, then he told Khogendo Sakma to buy a good pen and he is ready to pay 3,000 for that book. Thereafter, about 10 pieces of blankets were handed over to me and payments were made by Khogendo. Thereafter, we went to our own place and Sikon and Kogendo Chakma defense of the. So this is the story with regard to the fact that there is a meeting in the shop of Budul here. Kogendo Chakma. This okay. There,
But these transactions,
but
don't you think that they are not so much relevant?
relevant with regard to the fact that they know each other and they used to sit in the shop of Budul. Kogendo Chakma and Budul here. They know each other. They used to sit in the shop of Budul. That's why here from the evidence.
No, but the offense which we are trying to examine
But
is a much graver offense. It's not, these are not offenses that
No,
you
what I
know
want
each
to-
other, sit on a shop.
no, what I want to that's 120B. 302 Lordship Budulmia and Lordship Sauketo is not directly, but there is a conspiracy which has between Budulmia and Sauketo to commit an offense of 302 and Lordship 648, extortion of money. Because Lordship see the evidence of Sauketo Chakma. That is when I say that he has not taken exculpatory case.
Yes.
I interest.
Okay, we'll take a break of 5 minutes. No?
Okay,
No,
yeah.
these are not the findings.
Yeah.
Come to the findings.
Therefore, to examine itself. The items have been examined.
Page.
Number 78.
Next page.
Next. Therefore, to examine itself.
Hmm.
The items have been examined with the aid of scientific staff. Details of are noted on the 46 step. A full record of the work undertaken has fully documented record at the time the record at the laboratory. The DNA profiling of Shanti Balana have been established from their respective
No, this is of Santibala and Sipra. Now, along with the protool, let us see protool.
The full male, then the result obtained from the inconclusive, no reliable and reproduced DNA obtained from a male full profile was however obtained from the of the tumor bone concept that this exhibits your getting
No, but let us see the finding that
That
how do you match?
yes. The 177 was considered unsuccessful for DNA tests, but not but the DNA profile revealed a series of bands half of child inherit from its settlement. This case of the genotype says the peak profile to four. There at least one band with the profile. This is what I could expect to find for
Page
of the
380, the first conclusion. 380.
In my opinion, the result built above a strong support for the view that the super bones are from super file.
And where is this examination?
The conclusion for
No, that is the report. This is the report, isn't
this
it?
is the
Where is the examination as a witness?
exam. This is 209,
209.
volume 1, part.
Yes.
I have here it. I have honored degree biology and PhD holder in molecular and figures forensic science by forensic science have with forensic science forensic science my DNA that I set by get from the remaining with DNA help time exhibit 154 is my set. So the report and forbidden self. The report we have just now read. One detective supervisor officer came personally to my laboratory with a secure for often by the president. And there I carried out my at the time of secure normal public few content note record take for our purpose on test for my record. Those are not handed over to court method. In this particular case, I made some steps to photograph my own purpose, but on board. Active consider content my office for my office. After undertaking the analysis at our laboratory in my office, DNA results strongly support the tumor board. I examined originated the biological state of chip target. The assay and summary results have been provided at least that the technique and the machine in our lab is different that to have had the because of better object better result, but its laboratory other not be amplified the proper. I consider our laboratory one of the best labs in the world. As said, the report is really a normative from the fact that time of the box. Today I have produced for the 12-month product by for lab. Exhibit are the products our lab packets in for our lab. 20% the initial of carbon drop. Board as the assistant. I am acquainted here. Detective Superintendent Kelvin Mott personally and said for the order asserted that I by the analysis was done that the assert the to own the other material is to be accepted our laboratory from superpose. How for purpose that concept now for the cross to the
Cross is a 2-on-2.
2-1 from the not card draft card I take so tip card this from side of the number taken for it but collect by of but so for the last one last step collect complete these are the but like that to put it but
So you want to contend that there is no dispute with regard to the skeletal remains, that it belongs to Protul Dev and none other.
Yes.
It's been linked with the daughter.
more of the piece with photo that's it like
There is a suggestion, there is a submission coming that the model number of the pacemaker was not matching.
but lying up open so many kinds of what number one year is lying outside it followed it no not right third
Body was fully decomposed, only skeletals.
only step lying outside but pain for
1.5 years.
1.5 with people
That is the out of no doctor.
No, yesterday I've seen it was collected from England. They were at that time they were present there.
India, it was collected it
not it
and it was sent to your
No, it was not collected from India.
India in India all samples were collected
Shivani they but
India it was collected subsequently when the autopsy report of India Delhi lot it's England and then again lot the evidence of every model. Yes, one thing is correct, but every model didn't submit regard to collect. That's it. But Timothy is saying that Kevin Morton apply the the chemical. That is because the fact that the not that that about the six but sort of by the therefore part put one there I step that revision that to that for step
But that may not be a correct submission. That is not within the ambit of the court's jurisdiction. Permission is part of the government, appropriate authority. And so far as the meaning of life is, it's life. Why 14 years, why 20 years? There is it's very clearly.
that or in what 430 rest 430 rest that revision is that sentence minimum 10 towards table that's
But life, it can be, that's why normally people think that life is 14 years. Why 14 years? Have you seen that? Have you examined that aspect?
yes life 14 years because of the restriction.
What should the restriction be? Tell us.
What
That's not here.
I'm not wrong, but what yeah 44 430 430 minimum it will also put 438 4
Yes.
restriction on the power of revision or certain case. The topic for reading 438 430 power to
Yes.
the appropriate government may, without the consent of the person, sentence commute a sentence of death for any other imprisonment provided by the a sentence of prison for life for imprisonment for term not exceeding 40 or for fine. A sentence of vigorous imprisonment for simple imprisonment for term for any term which that person might have been sentenced or for fine. A sentence of simple fine. So this is the power for
Where do you get 14 years?
yes. Now Tortipe comes to 430. That's it.
Yes, please read.
Notwithstanding contains anything contained in section 432, where a sentence of imprisonment for life is imposed on conviction of a person for the offense of which death is one of the punishment provided by law, or where a sentence of death imposed on the person has been commuted under section 433 into one of the imprisonment for life, such person shall not be released from the prison unless he has served 14 days.
Where you come from? IPC.
What is the minimum and if the appropriate authority felt that if sentence is
Come to 55 of the IPC.
Right.
IPC.
Appropriate the
No.
commutation
IPC.
of central by
Yes, first you read 54.
54.
That is for deaths.
Yes.
In every case in which sentence of death shall
have been passed.
the appropriate government, that
May.
means the power which the has, may, without the consent of the offender, commute
Pun-
the punishment for any other punishment provided by this code. So that can be made commuted or changed by any other punishment. Now, what about life?
have been
In every case in which sentence for imprisonment or life has been passed, this initially it was transportation.
Yeah.
Now, after the change,
Yeah.
has been passed, the appropriate government may, without the consent of the offender, commute the punishment of imprisonment for either description for term not exceeding 14 years. Not exceeding 14 years.
that 14 years.
Maximum. But the government has the power
Of-
even to reduce to lesser for a period which is less than 14 years.
Yes.
Because the other day, Mr. Datta was arguing on 57, the fraction of terms of punishment. He says that he wanted to submit that in
Wait.
calculating fractions in terms of punishment, imprisonment for life shall be reckoned as equivalent to 20 years. But the submission is not correct. It is only for the purpose of determining the fractions of
Correct.
punishment, not for life, otherwise it's life. Okay, we conclude this then.
Shall I put-
You give a small written argument. Are you placing reliance on any judgment?
I think I put-
Yes. If the other
Yes.
councils also want, but the written argument should not be more than two, 3 pages. No, maximum three pages. Just nothing elaborate. Just mention which page, which number. Okay.
I just put add on the judge. Paragraph for 88. Here, it's for it, not is the punishment is given is for the highest
4%. Life.
Life.
and 30 not there.
এইখিনি ভালকে ৰাখিব লাগিব।
No. Group number was also not.
That's for it.
Group number was also 602.
Punishment was given for it, not fit.
Read the judgment. But the sentence is prescribed sentence. Conviction is under 364A.
Found not. Same. 125, 156. 88 as such the accused Sahadev Sakma, Krishnamadov Sakma, Kalapat Rudon Sakma are sentenced to undergo life imprisonment for committing 120 364 of the intent and also died to testify. In the event of failure for the reason of identical punishment awarded to these 6 convicts for having committed murder of victim. Here, identical punishment.
Same punishment. Taking note. Whoever wants to give some written along with indication to the case clause, but it should be very brief. If it is not brief, not required. Single division bench over. Single bench क्यों नहीं होता? अधिक probability bench है. पुराना मतलब.
Chapter number 6, maybe first week of April, Lord. Not 12 or 14.
Item number
6, Lord.
whole matter.
Lordship. Last occasion, Lordship. I also prayed for fixing the date today because other side was supposed to take time, Lordship. Today I'm not feeling well, Lordship. I prayed first week of April, Lordship. Any day subject
Not
to
first
Lordship.
week of April.
Sorry, Lordship,
Today is 13th. Next Thursday,
first week of April.
next Thursday, 20th, 20. 18 matter.
Lordship,
We are accommodating you for 1 week.
Lordship,
On 20th. 20th you do it. Other side informed.
Lordship, I already informed him.
A prayer for adjournment has been made on behalf of the petitioner.
Can it
However, considering
first week of
However, considering that the writ petition is of the year 2018, a slight adjournment is granted, directing listing of this matter on 2023. Yes, next Thursday.
Lordship, if subject first week of April, is it?
Cannot
I-
adjourn for 2 to 3
Two-
weeks.
2 weeks,
Three.
Lordship, because
What is the difficulty?
Lordship,
Do it on
I
20.
pray, Lordship.
20 is a short matter. 23. 23. Next Thursday. Yes.
For
4. Yes.
I have a case.
These are all matters. Next week, next Thursday, same order. Beastini.
I beg to make type number 17 mile.
17.
List of 1 week filers.
Why are you seeking time?
That actually my senior is not,
Senior is not what?
he is unwell filer.
Senior is unwell. All seniors are unwell today. Okay, item number
17 mile.
17, huh? Same. Beast no. Beastini.
Okay.
20th of March, yes.
Item
You got the relief. Anyone from the central
I have-
government?
of the
SS? Roy.
Roy.
Is it there in the court today?
Yes.
Heard Sri V. Kumar, Learned Counsel for the petitioner, as well as Sri S. Roy, Learned CGC. Para? Sri Kumar, the Learned Counsel, has submitted that during the pendency of the writ petition, the grievance of the petitioner has been redressed. Para? In view of the aforesaid submission, writ petition is closed. This is item number 18. Yes.
Keep it. May I please, Your Lordship? I beg to mention item number 13 and 14, Lordship.
Yes.
May case has some personal on next week, Lord.
Again, your mayor. Okay, this will be on 19th.
Yes.
19th March.
Yes.
13 and 14 on petitioner, huh? 19th March. Same order, huh? Written.
item number 8.
Yes.
I'm praying for an adjournment. That adjournment.
Item 8, year for whom?
I'm not on record, your Lord. The engagements they are out of.
Irrigation informed.
Yes, your
Oh,
They
uh,
come up 25th.
Not 25th. We'll have this on 18th.
What?
18th or 19th, whenever you say.
19th.
19th. Same order, huh? 19th. On behalf of the petitioner, 19th. Item number 8. 19.3.
Wait, period. I beg to mention item number 7 of this.
Hmm.
The consent of the other side, my lord, this matter may be posted after 2 weeks.
Why 2 weeks?
But if in this matter, Mr. A.M. Dotto and other council, they are supposed to appear, my lord. They are out of station, my lord.
So why 2 weeks? We'll have it next week. 20th, 23, petitioner. Inform the other side,
Yes, I'm taking.
Beastini.
I'll do.
It is, your Lord. I beg to mention item number 16.
16, yes. Yes, what is your prayer?
Lordship, senior is busy. High court.
Who is your senior?
MK Shah.
Okay, Tuesday next. On behalf of the petition, this will be on 18th. 18th, 18th.
Right. I beg to mention item number 19.
Okay.
This matter may be taken up after 2 weeks because in this case, we have made party United Bank of India. It is merged with Punjab National Bank. So we have to implement Punjab National Bank.
It is submitted on behalf of the petitioner that due to certain development of merger of banks, comma, an implement application is required to be filed. Full stop para. In view of the above, matter is adjourned by 2 weeks to enable filing of implement application. Timing is difficult. What is this matter about?
But to file a, but take a,
Hmm?
take a, but
Take appointment. Yes.
Kindly pass for the my senior will apply.
Okay, next Tuesday. Next Tuesday. Next Tuesday. A prayer for adjournment has been made on behalf of Sri K.K. Mohantaran Senior Council. Para. On the other hand,
they filed it. But that's up.
it was filed on 13/12/2024. How can they file without giving
I
it
have
copy?
checked.
We have taken
Uh,
copies.
The,
No, somebody has taken. Your signatures are there. You see who has signed. A prayer for adjournment has been made on behalf of K.K. Mohanta, Senior Counsel for the petitioners. Full stop. On the other hand, both Ms. R.B. Bora, Learned Standing Counsel BTC, as well as the Upamanyu, Learned Standing Counsel of Health Department, have submitted that the appointments in question are fake appointments. Full stop. Para. Yes, Mr. Mohanta.
It may be disposed of. I'm sorry. Long
Yes.
pending with.
Yes.
Yeah. But people kindly take up it.
Yes, please.
There are altogether
17, 18.
18 number of petitioners before this. Out of them, 10 numbers are working in grade 4.
Yes.
Why? For a people to put the spot. Enough is enough.
No, we are not adjourning.
Okay.
17 matter, you are not adjourning.
Yes. So they got enough time. They coming up with peaceful documents and all that way. And if necessary, lots will have that.
Out of 18 petitioners, 10 are in grade 4.
10 are in grade 4.
Which department? Health department.
Health department. Health department. One is a vaccinator. Vaccinator in grade 3.
And how is BTC involved?
BTC also, if you are working
In BTC.
under the BTC
Hmm.
earlier, that's how, because appointing authority, there they were appointed. And 6 surveillance workers.
Hmm.
6 surveillance workers and 1 statistical clerk. Is 18 petition.
One is a vaccinator.
1 is a vaccinator.
6.
6 surveillance worker. And 1 statistical clerk. Here, Lord Chief Mayor, in petitioner wise, if I may just mention, from petitioner 1, 2, 3, 4, 5, 6, they are surveillance worker. When 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, they are grade 4.
7 to
17,
7 to 14,
7 to 16.
16.
7 to 16 are grade 4.
Yes.
Grade 4. No, yes, 7 to 16, grade 4. Then 17 is the vaccinate.
Yes.
18 is
Statistical clerk.
clerk.
Yes.
Now, they were all appointed in a period from from 99, they were working, and in 2015, they were asked not to come to office. No removal order as such. No termination.
2016.
15, 1 5. 1 5. And here, initially their pay was stopped. They were working. Their pay was stopped. And then they approached this honorable court for arrear pay. That time, they were asked not to attend. And this is how they continued, and they are continuing. No termination order as such.
They are still continuing.
Not allowed to work,
Work.
because we were asked not to go to office.
No,
Orally.
when the pay had initially stopped, when
Ah.
the pay was initially stopped, you had come to the court
We have come to the court.
on an earlier round.
Yes. Writ petition 5061 of 2015.
Thereafter, you have been asked not to come
Not
for
to come.
duties.
Yes. We have not been paid. That case has to be withdrawn, because meanwhile, they passed an order. State authority issued an order that they termed us as a fake appointment, and then asked the authorities to go for inquiry and all. That's how we had to come before this honorable court, that you termed us as a fake appointment without causing any inquiry, without anything. And fact remains that, my lord, we are all working against substantive posts. Appointments were against substantive posts, substantive appointments. And we were holding this post, working, we were paid, everything was done. And then suddenly they say that you are fake appointee, and they stop us from going to the office without any order, and this is how we are continuing. Whether this is permissible in law? Are we not protected under 311(2)? That is my case. They have to take recourse to a particular procedure to find out whether that allegation is correct or not. Lot of people kindly appreciate it's a very serious allegation. I am playing fraud. If I have fraudulently obtained the appointment order, what was my role? How was it possible on my part to obtain it? Or who are the other persons involved there? Nothing was done. Now, kindly go to the annexes. Lordship will find. How were we appointed? First. Kindly come to page 23, annexer, page 21, that type copy Lordship may see.
21.
Page 21, annexer 1, page 20. In pursuance of the government approval, kindly see the wording. in pursuance of the government approval vide letter number such and such dated 17 December 25 to- and subject to discharge without notice and without assigning any reason thereof, and in anticipation of receipt of satisfactory PVR, the following person is appointed as surveillance worker under NVBGCP. Hello, this is National Vector-Borne Diseases Control Program. This is in full. National Vector-Borne Diseases Control Program. Centrally sponsored scheme. Lordship may recollect that time. There were kind of situation like pandemic because of this malaria, cholera type diseases and all of. Mostly Jorhat was very seriously hurt. That time this scheme came and appointments were made. Temporarily in this scale of rupees sustain trust plus other allowances as admissible under the rules in the existing vacant post. In the existing vacant post and placed at the disposal of the controlling authority as shown against the name. Next para. The appointment will be governed by the new pension rules issued vide government letter number dated 25th January 2005. The Finance SIU department has accorded approval vide their letter number dated 28th November 2005 and 5 dated 28 to 2008. So now there is an approval of the finance department. Then petitioner's name under the disposal of the Joint Director of Health Services issued by Dr. Dhruva Havzai, Director of Health Services, Assam. Original lordship will find at page 23.
Yes,
So similar orders. Next, these are surveillance order.
yes.
They are surveillance order. From here to next surveillance order खुल के आते हैं. Yes, up to page 34, these are appointment letters of surveillance worker. Annex 6, page 34, up to the Northern task, surveillance worker. All similar orders, all, as I find here, approval. Then kindly come to 7, Annex 7, 35. Petitioner 7, he is petitioner 7. Subject to discharge without notice and assigning any reason thereof, and subject to receipt of a favorable police direction report. This so and so, Jorhat is hereby appointed as grade 4 in the scale of pay of rupees so and so, plus other usual allowances as applicable under rules and posted at JTS Civil Hospital, Jorhat. Usual joining reports to be submitted in this. So he is appointed by Joint Director of Health Services, Jorhat. He is grade 4. Grade 4. So
Yes.
also page 37, lordship will find grade 4, similar order. He was also by Joint Director Health Services,
Okay,
Jorhat.
the orders, okay, orders. You have given the appointment orders of all the petitioners.
Yes.
That we have understood. Then thereafter,
And then lordship will vaccinator, lordship will find at page 54. appointment.
No, appointments you can skip. We have read the
Yes.
appointments.
Yes. So, Malad, these are regular appointments. There is nothing like. And one is this Silpa. Now, they are after we are working, we are transferred to other places also. We have given it. We are working. Notice will find that page 57. This is the order passed in WPC 5061 of 2015. That type copy.
50?
That WPC
Page?
page 57.
57.
Yes, 56, 57 is to 57. Prior to that, it is the appointment letters
56.
up to page 55. Then 56 is that proceeding 5061 of 2015.
This is the order at page
Yes.
57.
Yes. 57 is the order. Leave so and so. Petitioner seeks leave to withdraw this petition for filing with the liberty to approach this court again if so advised. Leave and liberty granted. Then so and so at no. Now, thereafter, this petition was filed. This is the order Lordship will find at page 58.
Yes.
It says, order dated 22nd of April 2016. In pursuance of government letter contained in their letter number dated 15 to 2016, the services of the following staff presently under the establishment of Joint Director Health Services Durhat, who with fake appointees, this Lordship should be removed from their services immediately, and local police station should be informed. Moreover, action should be taken for recovery of salary paid to them, if any. It contains 87 numbers of persons, this letter. Our names are there. LDA, grade 4, SW, surveillance
Yes.
worker, all total 87. Our names are there. And Lordship may see the last paragraph. The above person may contact the Joint Director Health Services of respective district with supportive, genuine document in respect of their appointment, if any, in order to take appropriate action in due course. So, in due course, they propose an action, and if there is any document, they wanted us to produce it. But this was not served individually to everyone. This was a common order. Subsequently, we came to know and we collected. Then, followed by letter dated 10th January 2017, page 59. This is from the Director of Health Services to the Joint Director of all districts, Joint Director of Health Services, regarding fake surveillance workers. Reference they have given the 7117 letter. In pursuance to the government letter so and so dated 7117, you are hereby directed to submit the list of surveillance worker. All relevant documents like service book, appointed orders, and transfer orders of the surveillance workers are to be placed before the screening committee for verification of records of genuineness of the incumbent. under your control. The format has been given, what is to be. Now, Lordship may also note here one thing, that this concerns on the surveillance of, not yet, grade 3, grade 4. In the previous letter or order, they call it, by which they are termed as spec upon it, at page 58, Lordship will find that they belong to grade 4, grade 3, all that, surveillance worker, vaccinator, surveillance worker, vaccines,
Yes.
LDA, grade 4, all were there. But the next letter, it refers to only surveillance worker. They were doubted physically, and their reports were asked for replaced before the screening. You are also last paragraph of page 59. You are also requested to be present with senior officer and respective head dealing assistant in the screening committee with duly filled format with all relevant records and all the incumbent surveillance worker here specifically mentioned are also to appear before the screening committee on the date and venue mentioned below, and if the incumbent surveillance worker fail to appear, they will be treated as fake appointee unless proved otherwise. Dates were given district-wise, Surat, 24th January 27. We appeared, submit. The copy of the notified screening committee is also
You
enclosed
appeared
here.
before the screening committee.
Yes. We had to go and submit. We submitted our papers. And then 28/3/2017, WT message at page 62. Number so and so dated 28/3/2007. Please refer to this department order number so and so dated 7/1/17 and so dated 27/3/17 relating to stoppage of salary of surveillance workers. Kindly see again, it is only concerning surveillance workers.
Yes.
The government in Health and Family Welfare Department has now decided to release the salaries of 953 numbers of surveillance workers whose credentials were found to be genuine. With the Director of Health Services letter number so and so, it is 7/3/2017, and consolidated statement of verification as on 19/3/2049. 19/3/2019.
It should be 2019,
That
perhaps.
should be 2019.
Yes.
Detailed list with names of the surveillance workers are mailed and sent by Director of Health Services. Sir, please take necessary action accordingly. Therefore, they say that out of 953 surveillance workers, they have released the found to be genuine 953, and their pay was directed to be allowed released. Now, what does it indicate is that the order by which, though they were termed as fake appointees, they were there. They were not paid. Thereafter, their pay was held. They were asked not to go to the orally. These are all orally.
But payment till that period is cleared.
Then next time, subsequently, it was clear for that. Some of 950 didn't clear our. They didn't come up with any definite thing. They have not.
Your salaries are still held up.
Yes, yes.
Held up.
We are just hanging on the same position. We are hanging in the same. How can they keep us like this? I understand. If there is something fishy, you can take appropriate action against everybody. Go into inquire, take action. Sometimes, if you at all feel like that, no, it's not it. I have a substantive right. of livelihood also. Hmm. Then, my lord, another regarding release of salary of surveillance workers, it is dated 63 at page, my lord. Malaria office Johar.
Yes.
Yes, this is also, I suppose,
63
WT message.
you have read already. 63
Sorry?
you have already read the WT message.
63?
Oh no, 63 you have not read.
No, we have not read. my lord. We have read the earlier one.
62 we have
Yes.
read.
It says, in pursuance to the, it is with Joint Director Health Services Johar, CMO and DMO Johar. In pursuance to the government order, video letter number so-and-so dated 27/3/17, directed to request you to release the salaries of the 51 numbers of surveillance worker of Johar district. 51 Johar district, 51 surveillance workers salary has been released.
So far you are concerned, your salaries have been released or not?
No. No. Twenty-four, 23/7. Next WT message was to the Treasury Office from Health Assam dispute. This was on 28/3/2017, page 64. To DEPCOM, Deputy Commissioner all district, Director of Health Department, that is the Secretary. Number so and so dated 28/3/17. Please refer to this department order number so and so relating to stoppage of salary of surveillance workers. The government in Health and Family Welfare Department has now decided to release the salaries of 953 numbers of salary. So we have already read it in earlier page. This is the original copy. 953 numbers of surveillance workers whose credentials were found to be genuine. Video Director of Health Service, letter number so and so, dated 7/3/2017, and the consolidated statement of verification as on 19/3/17, tell with the name are mailed and sent by director. We have already read it, the same thing, 950, 51, next 65. We have already released regarding that 51 surveillance workers of Johar. And the last annexer, annexer 22, is the details of the petitioners who joined when, where they are working.
Page 66.
Yes, page 66, 67, 2. Now, as I have already submitted, there are all these records pertain to surveillance work. They have probably made some inquiry within departmental level within themselves to verification of documents. And they have found so far surveillance workers are concerned, they were satisfied with respect of some people, 953 and 51 in Johar district, because we are all working under Johar that time, that's why we are concerned. And their salaries have been released, but ours are not released. Now, what is the then position in law? Well, there is no denial of the fact that we were working, we were paid, and those are regular appointments. Regular appointments were made to us in the sense that we were allowed, we are appointed in the against substantive vacancies, and we joined, we were working, we were paid. An employee of business, whether can be denied the service benefit or can be asked not to attend the office without taking any action as prescribed under the rule, including departmental proceeding and all. Enquiry, if made at some level by some people behind my back, or even if I was asked to submit the document, that would by no means absorb them from proceeding in detail the procedure as prescribed under the rule, more particularly made under 11.2 of the Constitution. Therefore, my limited cases method, you termed these employees as fake employees. What is the foundation? What is the basis? You label me as a fraud and won't give me an opportunity to deny, or you don't make an attempt to prove it before me.
The surveillance worker case, we have decided some cases of fake appointees.
Well, that is why I mentioned surveillance workers. Surveillance workers, worship has, they have cleared 953 or 50 plus 51. Sorry. In one case, I have seen an order of this Honorable Coulter Bat, 909 of 2016. WP. And one, I will come to your Lordship's order also. There is one Lordship's order. In this case, what the court has sought order, what the court has ultimately said, materials available on record. This is an photo. Better let us read it from third paragraph. At the outset, Mr. So-and-so, learned counsel for the petitioner, has submitted that he would be satisfied if this court directs the respondent authorities to reinstate the petitioner in her service forthwith, and the period of so-and-so till the date her such reinstatement be treated notionally. The learned counsel for the petitioner also submits that the petitioner would not claim back wages for the period from April 2015 till the date of her such reinstatement. This date where the petitioner is not objected to by the learned counsel for the respondent. However, Mr. So-and-so, learned standing counsel for Health and Family Welfare Department, submits that there is a doubt with regard to the initial appointment of the petitioner in her services, as well as the promotion effected to her case, and prays that liberty be granted to the departmental authorities to proceed against the petitioner in a manner known to law. I have considered the submissions made in the matter by the learned counsel securing for the parties and peruse the materials brought on record. The materials available on record reveals that the petitioner, after April 2015, for whatever reason that may have so existed, was not discharging her duties in the establishment where she was so posted as a junior assistant, and her salaries from the state debt was also not being released to her. It is further revealed that the state period, even if constituted to be a period of unauthorized absence, the departmental authorities have also not instituted appropriate proceedings against the petitioner in the matter. In that view of the matter, this court hereby directs the respondent authorities to reinstate the petitioner as a junior assistant in the establishment wherein she was last posted. The petitioner on such reinstatement would be released her monthly salary after the same is so fixed by notionally fixing the increment with effect from April 2015 till the date of her reinstatement in her service. It is provided that for the period the petitioner was not rendering her services with effect from April 2015 till the date of her reinstatement, the petitioner would not be entitled to any pay and allowances. Applying the principle of no work, no pay, however, the state period would be nationally fixed for the purpose of determining the pay of the petitioner on the date she is so instituted, for also for the purpose of her seniority in service as well as for calculating her pension and pensionary benefit. The reinstatement of the petitioner shall be so effective within a period of 30 days from the date of receipt of certified copy of this order by the Director of Health Services. The materials on record having also demonstrated that there is doubt with regard to the initial recruitment against the grade 4 post and her subsequent promotion against the post of LDA, junior assistant. The respondent authorities are at liberty to proceed against the petitioner after her reinstatement in her service in a manner known to law, and thereafter providing due opportunity of hearing to the petitioner by following the provisions of Assam Services Disciplinary Appeal Rules 1964. To come to a conclusion with regard to the said aspect of the matter and pass appropriate orders thereon. With the above observed,
Yes.
in my respectful submission, my lord, I pray the same relief. Similar. Because here also, as I open my argument saying that they having been appointed against substantive posts, allowing to work, continue to pay, arbitrarily they cannot be stopped or denied salaries. And I will say that for the time being, Lordship may say, yes, this need not be paid during this period for no work, no pay. But you, if you at all want to inquire and go ahead, find out and take the call thereafter. And if you find that those are all genuine, then they may be allowed the benefit because it was your fault, not our fault. If it is at all found to be. In the given factual situation and applying the law as prevailing, my respectful submission that I cannot claim anything against anything more than what has been already directed in this particular case. And Lordship has seen, my lord, here, only regarding surveillance worker, they have said so, but not against us, not a word. Why they have sound them as speaker? Nothing. So they will have to, if they at all pursue this allegation, they will have to clear it by giving opportunity to me, all such persons, to deny and substantiate their own allegation. This is there. And your lordship's order, your lordship's order dated 13/3/2020 in the WPC 4965/2016, Santan Bor Gohai and 57 others.
WBC?
WPC, my lord, 4965 of 2016. I'm sorry, my lord, I do not have an extra copy to pass on to your lordship. But here, my lord, I'll just point out certain things. Lordship has in factual part here referred to that verification process undertaken by
You can hand over your copy.
I'll hand over a copy.
Give the paragraph numbers.
Here, third prior lordship has noted the fact, has placed those in petition. One thing only I would like to point out here. In paragraph 19, lordship has recorded their submission that in paragraph 19, lordship has recorded like this. Sri Saikya at the outset has pointed out that none of the petitioners in the aforesaid writ petitions have annexed any of their appointment letters. And even details of such appointments have not been divulged. But we have already all this.
You have appointment letters.
Yes, we have all placed this up. Pointing out the pleadings in WPC number such that the engagement of the petitioners were made under a scheme during the period 2010-2015. Whereas the petitioner number 1 in the state petition states that he has been working since the year 2006. It is accordingly submitted that there is gross inconsistencies in the pleadings of the petition itself. No such inconsistencies could be pointed out here in our case by the law. Okay. It is also pointed out that there is no abandonment whatsoever in the writ petition regarding the recruitment process which was undergone by the petitioner prior to their appointment. By referring to the affidavit in opposition filed by the department, Sri Soikia categorically submits that not a single appointment / engagement of surveillance workers were done in the period 2010 to 2015. This submission of the learned counsel for the department is contradicted by their own document. In those affidavits have submitted in the affidavit dated 18/20/21, they have given the list of the employees and they have shown that the appointments of the persons who were already allowed to draw their salaries, whose salaries were subsequently cleared, they were appointed during 21/2015, 22/1/2015. They are listed. So that during 10/15, nobody was appointed. This is not supported by the document. Their own verification report says they were appointed there. And they are found to be genuine and their salaries were released. At page 5, this is there. So the facts may not have been gone into in that detail or is that clear. Therefore, ultimately this honorable court says, here it is regarding all SW, surveillance worker. Lordship dismissed the petition ultimately. Paragraph 44 and 45 lastly, Lordship said, this court has also been informed that in the present process.
We look into that case.
Yes.
I think this is a submission that your appointments were substantive in nature.
Yeah.
Against vacant post.
Yeah.
No denial that you had worked.
Yeah.
And after coming to the court for non-payment of salary has also been paid. There is no written order of discontinuation. Even if they want to discontinue or terminate, they have to follow the due process of law.
They have to have issued order.
Yes.
Nothing.
Yes.
Not done.
Will you hear the other side then?
Yes.
Lordship, here branch of it heard by this court
ordinance and this honorable court.
Hmm.
And Lordship, has given the deputy 5013 of steel. That was disposed of on
50,
5013 of 2020.
yes.
It was Lordship, date of judgment is 29/9/2023.
29/9.
2020. Lordship, there Lordship was not interfered with the removal. There also we have removed.
Similar.
Yes, these are all found to be fake. Lordship. In fact, we have given the list Lordship. In our affidavit that 88% were found to be illegal. And Lordship, surprisingly, Lordship, here they have only stated that there was an advertisement, they applied and they were appointed. But the process, Lordship, they will call for written test, whatever is there, they have not furnished, Lordship. Moreover, Lordship, the advertisement were never annexed in any of the writ petitions. Even in this petition, Lordship, I cannot see advertisement, Lordship. They were given ample amount of opportunity, Lordship. But Lordship, all this will have failed to give any supportive judging documents as to their advertisement, Lordship, and their Lordship.
Regarding
appointment.
any recruitment process.
Yes. Nothing, Lordship. And Lordship, there is a notification which has not been annexed in this writ petition, but in other case, Lordship, it's been annexed. There was a notification issued to all the joint directors that no joint director has the power to appoint during that week. Even on today, Lordship, the director of health service can appoint.
That notification is issued by director?
Yes.
By our government?
By government. And Lordship, that was furnished to the joint directors by the director of the Lordship. That Lordship, unfortunately, we have not annexed in this petition. But the other petition we have Lordship annexed. So Lordship, here Lordship, these people were given ample amount of time, Lordship. And there was a CM with the surveillance vigilance cell Assam who have asked us to inquiry to this matter, where it was found that when we have called them, Lordship, none of these people, Lord, this writ petition, even the BTC Council has also filed their affidavit the 12th of December, 13th of December last year. Even they have not found their appointment. Nothing is there. Lordship.
In the inquiry made?
Yes, Lord. And Lordship, I have also filed an additional affidavit, Lordship. Where Lordship, those 51 persons whose salary has been granted, Lordship, they were found to be genuine. Lordship. That is there in my affidavit. But this writ petitioners are not there. Their names are not. That 51 Lordship genuine candidates were found after the verification of the scrutiny board by the scrutiny board has been annexed in my additional affidavit. Lordship. I'm extremely sorry I did not have the running page Lordship, my additional affidavit. In my additional affidavit, Lordship, starts from page 4. The number of genuine persons Lordship were found after verified. And Lordship, dear Lordship, the list of these 88 candidates, Lordship,
Page. That,
of the 51 candidates.
no, genuine.
Yes, Lordship, that is at page 4, Lordship, of my additional affidavit.
Additional affidavit.
Yes, sir. It was filed on Lordship 16th of March 2021.
By respondent by 4.
Yes, page,
Affidavit in opposition by respondent number 4. Respondent number 6. Manmohan Moral.
no, Lordship, it is additional affidavit by the respondent number 4, Director of Health Services. Yeah, routine room. Lordship,
This is affidavit in opposition by Rathendra Bhuya.
yes, additional.
Additional.
Yes.
Additional affidavit by R4.
Yes.
Yes. 19 March.
Yes.
105.
$108.
It starts at 105, huh? You can.
Annex is
108, yes.
Lordship, this is the list, Lordship, here which we have annexed.
The
This-
scrutiny committee list.
Yes, this is found to be dead. This
they are found to be genuine.
None of the petitioners had named such.
Okay. But did they respond in response to your notice? Did they come to you with the documents?
Yes, Lordship, but they could not furnish that. Lordship, we have stated that. Lordship, they were called for, but they could not prove anything. Lordship. No genuineness to their appointment, no documents could be placed, because all this appointment letter is found to be fake. Thereafter, Lordship, there was a court order, Lordship, whereby they were asked to place the original of this appointment letter, which
Hmm.
they have. Lordship, that
In this proceeding?
in this, they have
Hmm.
furnished before the court. There was an order of the court. So then we were asked to re-verify their appointment letter.
Hmm.
That Lordship, at the inspection fee, I want to say, Lordship, there was a letter in this Lordship file. It is of 9th August 2023, which says, Lordship, that the other directors have been asked to give the report of genuinity as per the Lordship appointment letter provided by the petition. It was provided by the petition.
Hmm.
Lordship, that instruction is awaited. That is an issue, Lordship, because we have stated that it has been fake, Lordship, but since the petitioner counsel has repeatedly stated that there is a appointment letter and this appointment letter, so the court directed them to place it in original. Lordship. So they have furnished a few in regards to few of the petitions. 13 or 14, if not all. 13 or 14 people they have submitted their appointment letters, but that Lordship instruction will be very essential. Lordship, that instruction, Lordship,
When was it sent?
was sent back in the year 2023, Lordship.
Then
But Lordship, this is of 23, Lordship. So this instruction is of 23.
that is it.
Uh,
We are in 2025, March.
so Lordship, can we take up on this so that I can get, because otherwise, Lordship, as per our information, these are fake. Since this has been placed by the petitioner,
Mr. Mohanta,
so we wanted to.
Mr. Mohanta,
But
we'll
yes.
have it on Wednesday as
Yes.
part heard.
Yes.
We have heard almost complete. Your part is complete.
Yes. Well, I will just reply.
Let him come back. We can reply.
Witness.
Wednesday. Wednesday is okay for you?
When- Yes. 19. Maybe on 20th.
20. Okay. 28 will fix many matters.
It will not take much time. Let them break those things. The problem.
AC jana garam. Yeah. Heard Sri K.K. Mahanta, Learned Senior Counsel, assisted by Miss N. Begum, for the petitioner. Also heard Sri D. Upamanyu, Learned Standing Counsel, Health and Family Welfare Department, as well as Miss R.B. Bora, Learned Standing Counsel, BTC, Para. Hearing has remained inconclusive. List for further hearing on 20. Bistini.
Apply.
Yes.
It is your lord. My lord, this
Yes, Honorable.
petitioner
Yes.
was appointed, my lord, on 6/5/1995 as LDA. Just may kindly see the appointment order, my lord.
What is the issue?
Except for regularization, he
Yes.
worked for only 4 years, then like he's not there, he was not, his service was not extended. From 1999, he is not in job. So he is asking for regularization.
Yes, Mr. Gyasuddin.
7 years earlier, my lord.
Last you discontinued from 1999.
Yes, that's correct.
When did you come to the court?
My lord, I firstly come on 2000, my lord, and thereafter, my lord, again in 2005,
Hmm.
and thereafter 2017,
Hmm.
and my lord,
Thereafter
2008.
2018. You like the High Court very much, it seems.
Yes, my lord. I am knocking the door of my court. My
What did the court do? Send
lord,
you
they
back.
have taken the proposal, my lord, but later on, my lord, that proposal was, my lord, rejected by citing the impugn order.
Is
Earlier,
it
they have
possible to grant direct regularization in view of Umadevi 3?
but it with any
Hmm?
Yes.
May not be possible. Well,
But,
this is the fifth occasion you have come to the High Court.
yes, my lord, because my lord, this honorable court, my lord, earlier in every occasion have considered my
Okay,
Direct, my
let's try to see if we can do anything.
My-
1379.
mechanism. First appointment is, my lord, page 11.
Page 11.
Yes, ma'am. It's on 6 May 1995 by the Director of Industries, ma'am, as LTS. Ma'am,
6 May
1995.
95.
Yes, ma'am.
Subject to Richard one minute. Office of Director, temporary appointment. LD. Ad hoc.
Ad-
LDA. Ad hoc. Fixed pay. 900.
900
For 3 months.
for 3 months.
All against you.
My lord,
Ad hoc, fixed, 3 months.
3 months. Thereafter, lost to mechanically annexed to page 13, ma'am.
Yes, 1-3. Hmm. Extended.
Extended, my lord. It was, my lord,
What is the date of this order?
lost to-
What is the date of this order?
this order, my lord, original.
20 January
Yes, ma'am.
2000. Extension with 1 day break. Thereafter,
Thereafter, my lord, he approached this honorable court, my lord. I have not annexed.
after this, there was no extension.
Customer kindly see one letter, my lord, annexed T, page 16, my lord. This was in lieu of, my lord, WPC number 33/2000. I am, may I read my
Annex 3.
annexed 3, my lord.
Yes, what is this? Yes, 27.
27 March.
Director to Commissioner.
Yes,
Yes.
in this last paragraph, my lord, in this connection, it may be stated that post of LDA in Cottage Industries Museum, Shankardev Kalakshetra, is vacant due to reappointment of remit. If government approved and in the light of the Honorable High Court order stated, we may appoint Sri Pavan Mena in the state vacant post. Thereafter, lost to some communication law. Annexure 4, page 18, ma'am. there is a proposal, my lord, under secretary to the commissioner, industries of commerce. Proposal in respect of Sri Pawan Mena as LTA in vacant post of Cottage Industries Museum, Sankardev Kalakshetra, under the office of the Commissioner Industries. With reference to the subject cited above, I am directed to request you kindly furnish the proposal for filling up the post of LTA in the post of Cottage Industries Museum, Sankardev Kalakshetra, along with the retention and creation of the post to this department. So it was, my lord, this person name is mentioned here in subject matter. Because of that, a proposal was, my lord. Thereafter, Lordship, another, my lord, page 21, Annexer 7, on 19th September 2013.
Page?
Page 21. Lordship, this letter says, my lord, it was filling up vacant post of LTA at Cottage Industries Museum, Sankardev Kalakshetra, under the official service. In inviting reference to the subject and later cited above in pursuance of Finance Department poem number I am directed to say that approval is hereby accorded for filling up the vacant post of LTA at Cottage Industries Museum, Sankardev Kalakshetra, under the office of the Commissioner Industries and Commerce, as proposed, adhering to all existing rules and procedures. You are further requested to examine the matter and consideration the candidature of Sri Pawan Mena as per order of the Honorable High Court dated 5/9/2002 in WPC number 3322 2000. After observing the relevant provision of service rules, including reservation policy, he may be given some weightage for his past service and may also allow age condonation if needed. So this is, my lord, on, that is 19/9/2013. Thereafter, Lordship, I again approach this honorable court, my lord. Lordship, one of order I have annexed page annexer 8, page 24. This was, my lord, on 23/6/2017, when that proposal was pending before the authority. My lord, operating question, my lord, page 26. Having regard to the state letter dated 19/9/2013 of the Joint Secretary to the Government of Assam, the issue now rests on the decision which is required to be taken by the Commissioner of Industries and Commerce, Assam. The Commissioner is required to take a final call in the matter. Having regard to the above, this writ petition stands disposed of with a direction to the respondent number 2, that is Commissioner of Industries and Commerce, Assam, to consider the case of the petitioner in the light of the aforesaid letter dated 19/9/2013 and to take a final decision on the matter in accordance with the. So, and thereafter finally been ordered patient.
Yes.
So, my lord, that letter was, my lord, 19/9/2013, which speak about, my lord, for giving, my lord, some relaxation, weightage. Nothing has been given, my lord, but nothing they in order. And it was, my lord, basically, my lord, para 3, my lord. Joint Secretary has asked to consider the candidature of Sri Prabhan Mena as per OM number issued by the Finance Department, Government of Assam, and as per service rule and reservation policy OM referred by the Joint Secretary prescribes the procedure to be followed to fill up vacancies against the sanctioned government post. There is no provision for appointing or regularizing any master rule workers or temporary worker against sanctioned government. Therefore, the case of Sri Mena cannot be considered under the provision of the effort. Whereas, my lord, this post was created as per proposal of this petition. As per my lord proposal, my lord. Later, my lord, page 19.
Yes.
Page 18 and 19. But and my lord, as per my lord, my section is posted in the year 2018. Now I have to mention in my petition.
At the time of filing, post was vacant.
Right.
Yes. Vishal? Yes, Mr. Guldu.
But if the particulars of it will be clear from the affidavit that I have filed. I filed an affidavit in 7/2052. One of those petitions that petitioner has filed, order for this, the order is very relevant to make things clear. See the page 10 of it, that's the page of the
Of your petition. Of
my
your,
affidavit. I have given a type copy also. But
yes. 2702 is petitioner's case.
yes. So I'll just read out first. None appears for the
What is the date?
date. Lordship will find the original copy that is there at page 11.
1612.
Somehow it was not typed there. 16/12/2000.
2702. Yes.
None appears for the petitioner. I have heard so appearing for the respondent. This writ petition has been filed, praying for direction to the respondents to regularize the service of the petitioner as LDA under the respondent's effect from 28/2004, along with all consequential benefits of salary acceptance. As per own admission of the petitioner, he was appointed under the respondent's LDA, not against any post, as no post of LDA was sanctioned. He was appointed purely on temporary and ad hoc basis, and his service was continued from time to time. Be it stated here, the petitioner has passed HSLC examination, and as per the counter affidavit filed by the respondents, the qualification of the LDA is higher secondary pass with diploma in typewriting. According to the petitioner, the respondents have identified the post of LDA in cottage and museum, cottage industries and museum in Sankatet Kalakshetra, Guwahati, against which post the petitioner could be accommodated. On earlier occasion, the petitioner approached this court by filing writ petition number so, making the same prayer. The petition was disposed of by order dated 5/9/2002, providing consideration of the case of the petitioner. By annexure 3 communication dated 27/29/2003, the Director of Industry and Commerce, that is the point number 6, made a proposal for appointment of the petitioner against the vacant post indicated in the communication. In the letter, it was indicated the petitioner had rendered 7 years of service at a fixed pay of ₹900 per month. In the counter affidavit filed by the respondent number 6, it has been stated that the petitioner lacks basic qualification for appointment as LDA. As against the petitioner's qualification of HSLC, as per affidavit, the required qualification for appointment as LDA in the directorate is higher secondary pass or its equivalent, along with diploma in typewriting. Thus, according to the stand of the respondent, the petitioner is not qualified to hold the post of LDA. If that be so, it is not understood as to how the respondent number 6 could accommodate the petitioner for appointment as LDA by his letter dated so mentioned above. The counter affidavit has further revealed that the service of the petitioner was discontinued with effect from 1999. Thus, the petitioner is not in service for the last 9 years. If he is not in service, there is no question of regularization of his service. Secondly, if he is not qualified to hold the post of LDA, he could not be appointed as such. However, since the respondent has made a recommendation by so and so, the government may take an appropriate action in the matter. This court, exercising power of judicial review under 226 of the Constitution, cannot issue any mandamus directing the respondent to regularize the service of the petitioner. So the whole merit of the case cited. Then subsequently, Lordship by Lordship has already read out another petition, so that order was passed to consider by the commissioner. The commissioner's industry Lordship has passed this order, citing this some ministerial district establishment service rule, as well as one OM passed by the finance department. The financial approval, finance department approval will be required. There is a process to fill up, create a, so that cannot be done just like that. So those things Lordship, I have next today. So Lordship, one OM will be relevant, that is page 18. The Uma Devi case has been cited and then collectors.
Page.
Page 18 of my. Last 3 paragraphs, they have cited about, discussed about the case of Uma Devi and Jitendra Kalita, and they have issued this. They read out the last 3 paragraphs.
Yes, please.
In view of the order of the division bench of the Honorable High Court, dated 27/2012, this case number 2, read with judgment of the Honorable Supreme Court of India, dated 10/4/2006, reported in so State of Karnataka versus Uma Devi and other, and in pursuance of the approval of Cabinet, dated 7/6/2012, the government has decided that no more regularization of services of workers, master roll, or similarly placed workers can be undertaken by state government, even if such workers were engaged prior to 1/4/1993 and rendered for this. This is very clear. The face of this Lordship, we can't put. And in view of this OM, and Lordship, this his qualification, he is not qualified. Which is the qualification is given in the Assam Ministerial Establishment Service to 1967. So these two, if we take these two, consider it, the face of this cannot be. One of these cases is very clear about this much better.
45 of WA 45 was an outcome of this OM. WA 45, Read Appeal 45.
45. Read Appeal 45, the order is Malad 8/6/2017.
17. I think this OM was the subject matter of challenge 16/6/2012.
Yes.
Please see what was the subject matter of challenge that has been upheld.
Yes, Doctor, that is.
That 16/6.
Yes.
Because that was the state's appeal.
State
appeal because learned single judge has interfered with the 16/12. That was.
Then Lordship, it has been appealed, and like now the concluding part, I'll just read out Lordship. For these reasons, we are of the view that the petition case master role workers, charge workers, schedule workers are not entitled to regularization of their
Only
services.
they'll get the minimum pay.
minimum,
That is 45, I think.
and some medical.
That is
Medical,
45.
45 is.
45.
What is the decision and the date of the decision?
This is on 8/6/2007.
Justice Singh, Ajit Singh,
Just it's
45 of 2000.
45 of 2014.
State of Assam versus
State of Assam versus Pendas.
Upendas.
Pendas in 836.
That's all.
In their letter itself, which was issued by Joint Secretary, whereby it is kind of directed to consider my case, giving some weightage than other aspects.
No, see, weightage and
It's
age relaxation will come when only when there is an aspect of direct recruitment. But for regularization, there is no regularization. First precondition is that you need to be in continuous service.
Right.
Number one. Then you need to have the minimum qualification.
Correct.
First, even if we ignore for the time being the aspect of qualification,
Right.
but your position, you are not even in, sir, you are not a man in position
Yes.
at
And
that
like
time.
also, another
The question of regularization will not come. It will amount to either reinstatement or a fresh appointment.
he was not engaged at the first time. He is any substitute.
No,
But-
those aspects are already there, but even
Yes.
for the timing, let us assume that by the dint of serving for a long period of time, some right has accrued for a consideration for regularization. But can a regularization exercise be done if he is not in service at all?
Not there. He is not there from 1999.
99.
But though I am not in fact, but I am this my report. Since 2000.
No, regularization, the aspect of what do you regularize? Something which is not regularized. You are not even in service. How to regularize?
But
Okay.
I leave it a lot.
Please.
Oblige.
Now we are dictating.
Please, sir.
The approach to this court under Article 226 of this Constitution of the Constitution of India is with the following relief. Page 8. Para. There is a checkered history in this case, including history of history of litigations. Full stop. Para. The facts as projected in a nutshell is that the petitioner was appointed as an LDA on 6/5/1995 by the Director of Industries and was posted in the office of the HDRC Ambari. The said appointment was, however, stated to be on ad hoc basis and at a fixed payment of rupees 900 per month and for a tenure of 3 months. Full stop. It, however, appears that the arrangement was extended from time to time, and the last extension was up to 31/8/1999. Full stop. As the service of the petitioner was not extended, he had approached this court for the first time by filing WPC 3322 of 2000, which was disposed of wide order dated 5/9/2002. Full stop. This court had, however, observed that since for the last more than 9 years the petitioner was not in service, comma, the regularization aspect was not possible. Full stop. However, it was left open for the respondent authorities to consider the case of the petitioner. Full stop. Para. In terms of the said order, comma, a communication was issued by the Director of Industries and Commerce to the Commissioner, Industries and Commerce on 27/3/2003, making recommendation in favor of the petitioner. Full stop. Thereafter, comma, the petitioner had approached this court with the second writ petition WPC 2702 of 2005, which was disposed of on 16/12/2008. Full stop. This court had, however, observed that while the petitioner was a matriculate, the required qualification for a grade 3 post was higher secondary with typewriting. Full stop. This court had, however, accordingly observed that a mandamus was not possible to be issued, and it was left open for the authorities to consider the case. Full stop. Para. In the meantime, wide communication dated 29/4/2013 issued by the government, comma, the Commissioner, Industries and Commerce was asked to send a proposal in the Shankardev Kalakshetra for accommodating the petitioner. Full stop. Subsequently, on 19/9/2013, the government informed the Commissioner, Industries and Commerce regarding the grant of approval to fill up the vacancy, with a further observation that so far as the petitioner is concerned, comma, weightage for his experience as well as condonation of age could be considered. Full stop. As no further action was taken, comma, the petitioner had approached this court for the third occasion by filing WPC 3886 of 2017, which was disposed of by this court by order dated 23/6/2017, directing the respondents to take a final decision in terms of the proposal dated 19/9/2013. Full stop. Pursuant to the aforesaid direction, comma, the case of the petitioner was taken up and was rejected by the order dated 21/7/2017. Full stop. It is the legality / validity of this order which has been questioned in this writ petition. Full stop. Para. I have heard Sri G. Uddin, learned counsel for the petitioner. Full stop. I have also heard Sri A. Kolita, learned standing counsel, Industries and Commerce Department. full stop. Para. Sri Uddin, the learned counsel for the petitioner, has submitted that though the initial appointment was on ad hoc basis and for a particular tenure, comma, the same was extended from time to time, and the last extension was up to 31/8/1999. He has also submitted that by the communication exchange between the government and the Commissioner of Industries and Commerce, comma, the case of the petitioner was directed to be considered even by giving due weightage for the experience he had gained and also for condonation of age, full stop. He submits that submits that the proposal for filling up the post in grade 3 in the Sankardev Kala Khetra was mooted via the communication dated 29/4/2013 and was also further recommended by communication dated 19/9/2013. Full stop. He submits that in view of such facts and circumstances, comma, the approach of the authorities in rejecting the case of the petitioner via the impugned order dated 21/9/2017 is unreasonable and arbitrary. Full stop. It is also submitted that till the filing of the writ petition, comma, the concerned post in the Sankardev Kalakshetra was still vacant and the petitioner can be accommodated in the said vacancy. Para. Opposing the writ petition, comma, Sri Kolita, the learned standing counsel, has referred to the affidavit in opposition filed on 27/1/2022. He has submitted that though in the writ petition there is reference to the earlier writ petitions, comma, the orders passed thereon have not been annexed. Full stop. It is submitted that the said orders would have a material bearing in the adjudication of the present case, full stop. Para. Referring to the order dated 16/11/2008, passed in the second writ petition, namely WPC 2702/2005, comma, the learned standing counsel has submitted that this court had taken into consideration the aspect of lack of minimum eligibility qualification of the petitioner, which is higher secondary with diploma in typewriting. Full stop. This court had also observed that the petitioner was not in service for the last 9 years and therefore the question of regularization of his service would not arise. Full stop. The learned standing counsel submits that after such observation which had attained finality, comma, there is in fact no requirement for further adjudication. Full stop. The learned standing counsel has also referred to an office memorandum dated 16/6/2012 and has contended that as per the same, regularization, the exercise of regularization was discontinued. Full stop. It may be mentioned that the said office memorandum dated 16/6/2012 was the subject matter of a number of writ petitions which culminated in WA 45 of 2014, in which the decision of the government was upheld. However, with certain observation of grant of minimum pay scale and medical facilities. Full stop. Para. By drawing the attention of this court to the impugned order dated 21/9/2017, the learned standing council has submitted that in the said order, the relevant factors have been taken into consideration and the conclusion arrived at is strictly in accordance with law. Full stop. It is submitted that the according to law, it is accordingly submitted that the writ petition is devoid of any merits and liable to be dismissed. Para. The rival contentions have been duly considered and the materials placed before this court. Para. The initial appointment of the petitioner as LDA was wide order dated 6/5/1995. Full stop. The order itself makes it clear that the appointment was on ad hoc basis at a fixed pay of rupees 900 per month and was for a tenure of 3 months. Full stop. The communication dated 21/20/2000 annexed to the petition would, however, indicate that the services of the petitioner was extended from time to time, and the last extension was up to 31/8/1999. Full stop. The communication also indicates that the extensions were done with a day's break. Full stop. It is not in dispute that from 31/8/1999, the petitioner is not in service. Full stop. Para. The order dated 16/12/2008 passed by this court in WPC 2702 of 2005, instituted by the petitioner, has already laid down that the question of regularization of the services of the petitioner cannot arise, as at that time itself, the petitioner was out of service for the last 9 years. Full stop. Apart from the fact that the said order has attained finality, there are other factors which are required to be taken into consideration while dealing with the present challenge, qua the order dated 21/9/2017. Full stop. The impugned order dated 21/9/2017 has been passed pursuant to the direction of this court, passed in the fourth writ petition, WPC 3886 of 2017. Full stop. By the impugned order, it has been laid down that there is no provision for appointing or regularizing any master role, public work charge, or temporary worker against sanctioned government post. Full stop. Para. This court has also noticed that on 16/6/2012, an office memorandum was issued by the government, which has been annexed to the affidavit in opposition, whereby the regularization of services were discontinued. And as observed above, the said OM, the validity of the said OM was upheld by a revision bench of this court in WA 45 of 2014, by judgment dated 8/6/2017, bracket, State of Assam versus Upendas, bracket close. Para. This court is also para, no. The law regarding regularization has been settled by a catena of judicial pronouncements, and the landmark case in this field is Uma Devi 3 versus State of Karnataka, reported so and so, wherein the following aspects have been laid down, 153 paragraph. In the para, apart from the petitioner not fulfilling the requirements as laid down in Uma Devi 3, in the instant case, the aspect of regularization in service cannot arise at all, as admittedly the petitioner is not in service since the year 1999, and in the meantime, almost a quarter of a century has passed. Full stop. The said aspect was already observed and laid down by this court in the order dated 16/12/2008, passed in WPC 2702 of 2005. Full stop. Para. In view of the aforesaid facts and circumstances, this court is of the opinion that no relief can be granted to the petitioner. Full stop. Para. The petition accordingly stands dismissed. Yes.
Please.
In this case, Your Lordship, I'm not in contact with the client for some time, Your Lordship. So I may pray for some time, Your Lordship.
Which department?
Your Lordship, this is Indian Post Payment Bank, Your Lordship. There was an advertisement for appointment, Your
Who are
Lordship.
you? Who is one? Or for the CGC? Central Government Service.
Yes, Your Lordship.
But 18 matter, we are not, already had granted time on the last occasion. That was a long time back, 2022.
Yes, Your Lordship. I appreciate.
We'll have it on Friday next. 1 week. If you get in touch, otherwise.
Okay.
Sri R. Sinha, learned counsel for the petitioner, submits that the client is not in touch, and therefore he does not have the latest instruction. Full stop. He accordingly prays for some time. Para, in the interest of justice, a short accommodation is granted, directing listing of this matter on Friday.
Lordship, may I pray for 25th or 26th if it's not inconvenient? I'll leave it to you.
We are giving when? 24th. Okay, 24th, Monday.
Deeply observed.
Sorry.
Your Lordship, there is an interim order that makes sense.
Interim order passed earlier to continue it the next day.
Deeply observed.
Yeah, Janan, what is that?
The previous. Here in this test method, the private respondent number 5 was promoted to the post of junior assistant by ignoring the amended provision of the Assam Ministerial Administrative Establishment Service Rules, wherein the original criteria for promotion was by Lord higher secondary, then it was by 1994 notice amendment, it was made to high school, and in
But who are you? Are you eligible? Are you eligible?
I am
Not eligible, but in
You-
fact, my friend has not annexed the regulation order. I have got a copy of the regulation order, Lordship.
Of
Yes.
whose services?
His service. His service, Lordship. He has regularized against a personal post. So, my friend
they
has,
have not put any affidavit in the
Yeah, I have
15
received
matter,
one.
my lord.
Give a copy to him. Give a copy to us. We'll close this.
I will give a copy.
We'll close this.
This copy I can give.
Tell us your case in brief.
Both the petitioner and the private respondent were working as a peon in the grade 4 employee, and both were regularized in the year. Both were response 7. (22 7 2005), and initially
Just a minute. Just a minute. You were working as what? Appointed as?
entered in the service as master roll laborer in the year 89, February 18.
1989.
Yes. And
Initially, irrigation
And
department.
my service was regularized with
Irrigation department.
irrigation department, Lakhimpur division irrigation.
Okay. Thereafter,
Hereafter, with effect from 22 7 2005, I was regularized. And while after regularization, both the petitioner and the respondent were serving in the capacity of peon.
as peon.
Yes, ma'am. And
Along with R5.
R5, yes, ma'am. By impugn order dated 8/1/2018, in Exhibit 3, my lord, page 7. The R5 was promoted as junior assistant. Where is the, my lord, the educational qualification is by the 2015 amendment degree, and whereas the private respondent R5 is holding a high school living certificate only, and whereas the
Matriculate.
petitioner was graduate in arts, in Exhibit 1, page 12, my lord.
Amendment requires graduate.
Yes, my lord. In view of the 2015 amendment,
What is the post you are upgraded from peon to grade 3?
junior assistant, LD, erstwhile LD.
Okay. Then he has a case.
Yes, my lord.
Lordship.
If he says that he is holding a graduation degree,
Lordship, his city regulation, Lordship, is against a personal post. And Lordship knows the federal law, Lord.
and the R5,
R5, Lordship, if he is wrongly promoted, he would be reverted back, Lord. I have already instructed my client. Lordship.
but what do you gain?
This has come for the first time because this what
No,
were
no,
the information provided, my lord.
No, are you aware that your regularization was against a personnel post?
That
Let
was-
us see your regularization order.
that I have to
He
take
has not
instruction.
annexed, Lordship. I have got a copy, Lordship.
Okay, my lord, may come upon then 25th. I will take the instruction because I am also
No,
not
first,
interested.
if your regularization is against a personnel post,
Okay, ma'am.
then to get a higher promotion from the personnel post will not be possible. Second aspect of your challenge is on the basis of the amendment of 2015.
15.
But where you have contended that the respondent number 5 is not a graduate.
Yes.
Even if your contention is correct, it will be causing unsettling the respondent, which you are still, but what is your right?
Yes, I understand. That instruction I will obtain.
This is not a co-warranto. You are asking for certiorari jurisdiction. To have certiorari, if first yourself, you need to be eligible.
Yes.
Have you prayed for co-warranto? No, I don't.
No,
think
madam.
so.
Only for setting aside.
Setting aside will not do. You can question by what authority? We can make an observation to look into R5, but huh? Under what consideration you have given R5? R5 has been served.
Yes, my lord. Service is complete, but in spite of it, it's but last order.
One observation may cause harm to her also. Depends on you. How many years you have in the service?
Since regularization of 2050,
What is your age now?
around, I think, by the affidavit,
Around
it's by
50,
56.
56.
If you go
Some
by
more years to go, and the S1/5?
same, only for 5 months difference. No, I think he is senior. He's I have hotel
Both are, both of
1664. Respondent's date of birth is 1696.
is about to retire. Not
He's
about
about to retire. Then we'll close this. Okay, no more items. This is the last. Okay. Third. The Sri G. Jalan Learned Counsel for the petitioner. Also heard Sri N. Upadhyay, Learned Standing Counsel, Irrigation Department.
1, 2, 3, 4.
Irrigation Department. Para. The instant writ petition has been filed with the following relief. Full stop. Relief to court code, page 9. Para. As per the facts projected in the petition. No, the facts projected in a nutshell is that the petitioner was initially appointed as a master road worker in the irrigation department, Lakhimpur, in the year 1989. Full stop. Subsequently, he or she, you or he, his services were regularized as a peon wide order dated 22/7/2005. Full stop. It is the case of the petitioner that similar benefit of regularization was also given to the respondent number 5. Full stop. The grievance of the petitioner is, however, in connection with the promotion granted to the respondent number 5 as junior assistant, wide order dated 8/1/2018. It is averred that such promotion is not in accordance with law, as the respondent number 5 does not have the eligibility criteria. Para. Sri Jalan, the learned counsel for the petitioner, has submitted that the services of the parties are governed by the Assam Ministerial District Establishment Service Rules 1967. Full stop. It is submitted that the aforesaid rules have undergone amendments, and as per the present requirement, for promotion to the post of junior assistant, an incumbent is required to be a graduate. Full stop. It is contended that while the petitioner is a graduate, the respondent number 5 is a matriculate. Full stop. He accordingly submits that the order of promotion of the respondent number 5 is liable to be set aside with a further direction to consider the case of the petitioner. Full stop. He has also informed this court that though the respondent number 5 has been served, the said respondent number 5 has chosen not to appear and contest the writ petition. Para. Per contra, Sri Upadhyay, the learned standing counsel, irrigation department, has submitted that the entire facts have not been revealed in the writ petition, and a very important aspect regarding the process of regularization of the services of the petitioner has not been disclosed. Full stop. He has submitted that the regularization of the services of the petitioner was in terms of a general order dated 3/10/2005, whereby certain posts were created only for the purpose of regularizing the incumbents which were personal to them. Full stop. It is submitted that the petitioner is a beneficiary of the said process. Full stop. In this regard, the learned standing counsel has placed before this court the aforesaid order, aforesaid communication dated 3/10/2005, along with the enclosures which contain the name of the petitioner also
Serial number 4, Lord.
at serial number 4.
Sure.
What about the respondent number 5? Is she there?
He is from the different division, Lord. In this,
Okay.
he is not.
The learned standing counsel accordingly submits that when the petitioner himself submits that the regularization of the petitioner being personal to the post, his claim for promotion is not maintainable. Full stop. Para. Sri Jalan, the learned counsel for the petitioner, however, fairly submits that this aspect of the matter was not made known to him at the time of presenting the writ petition. Full stop. He, however, submits that the other aspect of the matter would still be open for consideration, as there is no denial of the fact that the respondent number 5 does not have the eligibility criteria so far as promotion to the post of junior assistant is concerned. Full stop. Para. After considering the rival contentions, this court has noticed that the challenge was structured regarding the promotion of the respondent number 5 with a consequential relief to consider the case of the petitioner, and in this regard, a writ of certiorari was prayed for. Full stop. While it is a matter of fact that the allegation against the respondent number 5 has not been denied, this court has taken into consideration that both the petitioner and the respondent number 5 are at the verge of the retirement, and in fact, the respondent number 5 appears to be.
As per para 4, Lordship,
Yes,
if
my-
he was born in 1664, perhaps he retired.
And as would appear from the pleadings, it would appear that the respondent number 4
Right.
and 5 has already retired. Full stop. This court has also noticed that the relief prayed for was in the nature of a writ of certiorari and not a writ of quo warranto. Full stop. In any event, considering that the respondent number 5 has already retired from service, or maybe at the verge of retirement,
Yes.
the interest of justice may not call for interfering with such orders of promotion, which was done more than done in January 2018. What's the para? In view of the above, comma, no substantial relief can be granted to the petitioner, and accordingly, the writ petition is closed.
All right.
The communication dated 3/10/2005, along with the enclosures, are made part of the records.
Sure.
Rest, it should be given. This is the last. Another again. And wish you all a very happy Holi.
Same to you, Lordship. Same. Lordship, last April 21. It may be fixed on 21st April.
We'll give date, don't worry.
Ah.
What is the urgency?
Lordship,
What is the urgency?
21 case for appointment selected.
Okay,
They,
we'll
they were
give-
selected, but
Mr.
not
Das?
appointed.
we can have it today,
April, may.
huh? Today we can have, but you know the result. 18 selectors, what will you get? Nothing. If you want, we can dismiss it today, should we? You get relief. No more phone calls from the client.
After due vacation.
Dismissal after Bihu vacation. Okay. Peaceful Bihu then, okay.
All right. হ্যাঁ 21 তারিখ 21 এপ্রিল সোমবার দিব নেকি নালাগে দিয়ক ইমান সোনকালে 21 এপ্ৰিল তাৰমানে মই 12 এপ্ৰিলৰ পৰা 18 এপ্ৰিললৈকে হায়দৰাবাদত থাকিম ট্ৰিটমেণ্টত যাম